procedure. This webinar is one such an attempt of ours to bring the students near the aspect near to the aspect of practicality. I indeed want to thank everyone for attending this webinar. It is great to see all of the students who are taking part. I am honored to welcome our first presenter, Mr. Neil Datta, an associate at Vadia Gandhi & Co. He comes with more than four years of experience in the field of IP litigation. He holds a thorough passion and also specializes in trademark and copyright practice. I am glad that Sir is present here to share his knowledge regarding the same. Lastly, a small clarification and a notice to the participants. If you have any question during the presentation, please type them in the chat box. I'll present it at the end. Without further ado, we'll start with the webinar. Over to the presenter.
Hi, that was fast. Thank you so much for introducing me to this webinar. And also, thank you for inviting me. Thanks, Simona. Am I audible, guys?
Yeah, you're audible.
Okay, cool. So, I'm here, been asked to present on the trademarks and copyright practice, which we have in India. So, I'll just share my screen so that you guys can see my PowerPoint. It's a very basic PowerPoint presentation. Mostly I will talk about it. Can you see the screen? Is the screen visible to you guys?
Yeah.
Yeah. So good morning. Here I am going to waste 2 hours of your time. I think I should not waste, but I'll try my best so that to keep it entertaining on a Saturday morning. Anyway, let's start with the copyright practice first. Now, see, a copyright application is normally filed in the Copyright Office, which is located in Delhi. Unlike the trademark offices, a copyright office only has one branch, that is in Delhi. So, trademark offices, as there are the registration process is quite long, and also the number of trademarks are very vast. So, they have like 4 branch offices apart from the head office that is in Mumbai. But copyright office, the applications are not that much as compared to a trademark application, and therefore they have only a Delhi office. Now, why the copyright applications are not that much? We have to understand the very basic of copyright law. That is, whenever you are bringing something into the world from your mind, that is, be it music or be it art or be it words that you write for your prose, poetry, stories or screenplay, whatever. The moment you create that work, the copyright subsists in it. So a separate registration is not required. If somebody infringes the work, you can always institute a suit for infringement or passing off of that particular work. But there you have to establish that that work has been developed by you and it has been brought to this world first by you, it has been made public by you, or maybe it is unpublished or published. Whatever the fact is, you have to prove that the work belongs to you. So in order to make it smooth, some big corporations and even individuals register the work, the particular copyright work, because it's very difficult to prove in the court orally that, okay, you have first made that work public, or you are the owner of the work, or you have clicked that photograph or something like that. Now, that's why a legal document which shows you that you are the owner of the copyright gives you a mileage in the code, gives you that locus standi that, okay, I'm the owner of the copyright. Nobody can challenge that. Now, whether it's infringed or not, that is the question of the court needs to go into. Now, so therefore, some of the people go for this copyright application process, a very simple application process, not as complicated as trademark. So I'll just go through it within like 10-15 minutes. So now, as you can see, the copyright application the author of the work. I'm here, I'm taking an registration of copyright in an artistic work. How you file a registration of copyright in an artistic work, how do you obtain it? So therefore, the author of the work, copyright claimant, owner of an exclusive right for the work, or an authorized agent filed an application, either physically in the copyright office or through speed post, registered post, or through e-filing facility available. Mostly we follow the e-filing facility because that's swift, that's easy. So if you are author of the work, you can go to the copyright office and you can file the application. If you want to hire an agent or an advocate, you have to give the person a power of attorney, and that power of attorney needs to be attested at the time of filing the application. So therefore, the registration of each work, a separate application must be filed. As you see, the register along with the particular work needs to be examined separately. So if you have, for example, two poems and you want to file a single application for two poems, you can't. You have to file separate applications. So poems again will come under literary work, and we are right now dealing with artistic work. I'm not going into the concept part of it, what is an artistic and what is a literary work, because I think the professors in your college will be able to explain that. Anyway, so going forward, the fees for a copyright application is 500. Now, if the work is being used in respect of goods and services, or is capable of being used in respect of goods and services, it will be charged. The application will be charged 2,000. Now, what do you mean by the work sought to be registered is applied on goods or is capable to be registered in respect of goods and services? For example, you have an artistic work in your hand. For example, maybe a logo. Okay. Now the logo is embossed on a cloth. So you want to register that particular work, that the cloth embossed logo, as an artistic work under the copyright law. Now the registrar of copyright may ask that whether this particular work is capable of applied in respect of goods and services. If it's capable of applied in respect of goods and services, then you have to obtain a no objection certificate from the trademark registry. Because if it's capable of registered in respect of goods and services, applied in respect of goods and services, then it's a trademark and not a copyright. Okay. A trademark distinguish a particular goods and services from that of others, and that is the whole point of trademark. So if you're confusing between a copyright and a trademark, then your work need not to be registered in the copyright office, and it's a trademark. So therefore you have to be very particular as to what's the copyright and what is your logo or the work you want to register in an artistic work with the copyright office, uh, is capable to be registered or capable to be applied in respect of goods and services. If yes, then you obtain a no objection certificate from the trademark registry and get it attached with your copyright application for while you are applying for the copyright application. Now, going to the next part. Now this is it's very self-explanatory. Now this is the form 14 you need to fill up when you are filling up the copyright application in respect of artistic work. Now it's quite interesting to see what you now see. I think I'll just share the form for you. Mm. Are you guys able to see the form, Simona?
No, sir.
Okay, one second.
I think you have to share screen again and
Yeah. Can you see?
yes.
Yes. So this is the form which we need to fill, the form 14 of the copyright uh, rules 2013. Now, see, the first we have the name and addresses of the parties. So this is where you write the person who is applying for the copyright. Now you have to understand a copyright. There's a lot of ownership issues in copyright. Now, a person who has came up with that particular work need not to be the applicant for the particular work when he's applying for the application. Uh, For example, I came up with one music. I am a music writer. So for example, I'm a lyricist or a music composer. So I came up with that work, and then I assigned that particular work all the rights to file the application or to exploit the copyright in that particular work to a producer. Now the producer goes ahead and files the application through this form. Okay. Now then I will be only captured as an author and not the applicant. So whoever is the applicant need to file this is required to show its name in this particular form, the first entry which we have in the form. So therefore, if I am the owner of the photograph and I am only filing the application, then I will only write my name in the particular form. So I'm the applicant. So this is very basic. So applicant address. So date of dispatch is the date when you file the application form on, you fill up the application form and you file it with the registry after paying the necessary fee. So that date needs to be captured here. Anyway, these things are automatically filled, the next 3 and 4 in the online filing system. This is just a form. So online filing system has a separate HTML layout. Anyway, the communications on the subject may be addressed to, if you can see point 4, this is where the advocate's name need to appear. If the form is being filed through an advocate or an agent, whatever, as it is necessary. Now the advocate's name and the address needs to be captured here. Now, the next thing which we have, this 5, 6, 7 is not, this is automatically filled. Now the statement of particulars. See, this is the necessary information you have to give before you while you're filing the form, that is a statement of particulars. Now see, the name and address of the nationality of the applicant, these are all self-explanatory. Nature of applicant's interest in the copyright of the work, maybe the owner of the work or the applicant of the work. Okay. Class and description of the work. The class and description will be artistic, literary, or musical, anything which you relates to the work, which the work is, right? Title of the work, you need to have a title of the work. Language of the work, whether the language is in English or any other language. Now name and address and nationality of the author, and if the author is deceased, the date of disease. See whether work is published or unpublished. Before filing of the application, if your work is published, you have to say yes or no. So anyway, if not published, so these are all self-explanatory. If you can see, there is not a single thing which is difficult to understand. The work, it's available in the Copyright Office. You can just download and go through it. And if you have any queries, you can just drop me a mail or something. See, I'll still go through each one of them. Years and countries of subsequent publications, if any, and names and address or nationalities of publisher. Mostly the copyright applicant who are applying for the registration of their work don't publish it, because if they publish it, it will go to the public domain. The entire point being registering a work is I'm just being very, very proactive and secure about my work, and therefore I want it registered first and then I'll publish. So this are not to be not filled mostly, but yeah, if it's published, then yes. See, names and address or nationalities of the owners of various rights comprising the copyright in the work and the extent of rights held by each, together with particulars of assignment and licenses. See, this is a very important point. Why? Because if there are various owners to the particular the owners of the title of the work, then you have to mention their name, because they are very related parties and they are concerned about this particular application. For example, if in a particular you have written a book, for example, let's take the example of Amish Tripathi. Amish Tripathi has written a book that is Immortals of Melua. Now Immortals of Melua has been translated into different languages. Now even though Westland right now is the publisher and is being publishing all the books in different languages, let's take a scenario where Westland publisher is not the only publisher who is publishing that particular book in different languages. For example, Westland has published in English language, or maybe ABP has published in Bengali language, or some other in Marathi language. So see, there are different publishers who has a particular right to this particular book. Now, even though the book has been written in English, the book has been adapted in different languages. The translations were there, transliteration were there, sorry. So those people's name need to be mentioned there, because if you are filing an application, they need to be informed, okay, I have this is a particular work where I'm exploiting in Bengali or Marathi. This particular work which has been written in English, as in is being used to file an application. So those parties need to be mentioned there. All the related parties where the particular assignment or license of that particular work has been given to, those parties' name needs to be mentioned there. These the next names and addresses and nationalities of other person, if any authorized or assigned or licensee, the right comprising the copyright, again the names of the people. If the work is an artistic work, the location of the original work, including name, address, and nationality of the person in possession of the work. Again, this goes with the this is where we fill the name of the author and the name of the address of the author if the author and the applicants are different. If not, then you just have to say same as author in the online application form, and automatically captures the author's name and address. See, this is the section which we spoke about in the previous page. That is the TMC certificate, which we need to ascertain whether the work is capable to be applied in respect of goods and services. So in a similar scenario, once a matter came to me, there the applicant need to file a registration of the copyright of in their artistic work. Now their artistic work was a card. It was a different style card which has some mechanism in it. So therefore they claim that to be a different kind of work, and therefore it's an artistic work. So therefore we said it's okay, let's file a copyright application. Now on that artistic work, there were names, the names of the company were there. So basically that was a business card, and that particular card has name of the company there. So the Copyright Office came with a query that if the names of the company are there, then we can't register. We need a TMC certificate from the Trademark Office. Then we went to the Trademark Office, and the TMC certificate was issued. And before the TMC certificate was issued, the examination report was there to check whether that particular name has similar trademark has is similar to the trademarks right now there in the registry, that particular company's name, and whether that particular work can be used as a trademark in respect of goods and services. They came with the objections, and then we replied saying, no, you cannot use as a goods and services, because this is a particular business card. Business card is not used in respect of goods and services. It's just for an information basis. The entire work which is there, the work on the business card, is a copyrightable work, and therefore no trademark can be the work cannot be used as a goods and services. Like you cannot sell your goods and services using that particular card. And therefore we cleared the objections, and after that the work got whatever rejected or registered. Let's not talk about it. If the work is an artistic work, whether it is registered under the Design Act 2000, if yes, give details. So again, if the work is an artistic work, because Copyright and Design Act have very similar definitions of what is uh, what is art or design. For example, the Design Act also provide registration for a copyright of an article. So I think that's the domain of the professor. Will not go through the domain thing of the professor. Will not go to that thing why design and copyright is so similar and why they are overlapping rights in there. Again, the same thing, if the work is an artistic work, have the design work, whether it is applied to an article through an industrial process, and if yes, the numbers of time it has been reproduced. Why it is necessary? Because there is a provision in the Copyright Act which says if a copyright is there in an industrial application, it has been reproduced more than 50 times through an industrial process, then the work is not capable to be registered as copyright, but to be registered as design. Now in the remarks column, you may add anything about your work which you need to add, which says that, okay, uh, this is the type of the work. Maybe there is some specific things you need to mention about your work. There are different kinds of work. So it depends on the subject matter of the work. Statement of further particulars only for literary work, including software, dramatic, music, and artistic work. Again, these are all self-explanatory, so I'm not going to it line by line. Excuse me, sorry. So yeah, then we'll again go back to our PowerPoint presentation. This is the form which you need to file the copyright application. So after the form is filed, you have to furnish some of the documents, because see, copyright in essence is a work created, so you can feel it and you can feel it in your hand. So you have to actually submit to the office the copyrighted work, or the work in which you are claiming copyright. So therefore, 2 copies of the work need to be published, need to be served with the registry. 3 copies of the work if the work is unpublished. Sorry, if the work is published. I'm sorry. This is wrong. 2 copies of the work if the work is unpublished, and 3 copies of the work if the work is published. Now, the DD and IPO of the payment as applicable for the per work need to be submitted with the application. This is not necessary because in the online filing system, you have already paid the money before you send this work. At the time of filing the application, you already paid the money. NOC from the author if the applicant is different from the author. Again, when I explained that applicant can be different from the author when filing an application, therefore an NOC from the author is required. NOC from the publisher of the work if the publisher is different from the applicant. Normally, the copyright in a book is applied by the publisher and not the author. Author does have the moral rights. They cannot change the name of the author anywhere, but the copyright in the book rests with the publisher, and they have the power to exploit its royalty, exploit its revenue earned by selling the book anyway. Now the search certificate from the trademark office, that TM60 was there under the old rules, that is trademark rules 2002 if I'm not wrong. Anyway, and TMC under the trademark rules 2017. So they have just changed the name. This is the same trademark certificate if the work is being used on goods or capable of being used on the goods. This particular certificate gets issued by the trademark office, which you need to attest in your application. NOC from the person whose photograph appears on the work. There can be a book which you want to file for registration of copyright, and therefore there can be many photographs in the books which are appearing on the book. So therefore you need to obtain a no objection certificate from those people as well, because each and every work, whether photograph or music or uh, any kind of thing which is coming out of your brain, are copyrightable works. So you cannot register your book, and which includes other people's work, and say no, the entire thing is mine. So you have to show the rights in those particular photographs or the caricatures or the art which appears in your book. So you have to obtain the NOC from the person. NOC is an objection certificate. If the application is being filed through attorney, a specific power of attorney in original duly signed by the applicant and accepted by the attorney needs to be filed with the work. Now, this is the next process of the application, that once the diary number is issued, there's a minimum of 30 days waiting period. In this time, the copyright examiner reviews the application. Uh, Now, just one sec, some work. Demerits of being a litigation lawyer. Any time of the day and the night, the work pops up. Anyway, once the diary number is issued, so when you file an application, the Copyright Office issues a diary number. The diary number is issued and they publish. There's a minimum 30 days waiting period. In this time, the copyright examiner reviews the application. In case no objections are raised, sorry, I need to take this. Excuse me. So once the diary number is issued, there's a minimum 3 days waiting period. In this time, the copyright examiner reviews your application, and uh, then the examination report or a kind of a scrutiny report is issued. In case there is an objection, the examiner goes ahead to review the scrutinized application to find any discrepancy, and therefore a scrutiny report gets issued. Uh, if there are no objection, then the copyright application gets notified in the Copyright Office website to show any third party if they have any objection to that particular the copyright application. If the examiner finds any objections, then after issuing the scrutiny report, on receipt of such report, the applicant has 30 days period to respond to that report, saying that what all things are not improper, and we have to address the issue, what all things are improper and what all things are proper in that particular copyright application. Basic After the receipt of the letter, again the copyright application gets reviewed and renewed. Sometimes these discrepancy letter or the scrutiny report gets issued time and again by the copyright office, maybe 2 3 times, and each time you have to respond by saying no, this is proper, this is proper, this stage is also proper, the copyright work. So these can be different things. For example, you may have filed an application in the artistic work where you have claimed that this work cannot be used in respects of goods and services, but the register of copyright came back saying no, this can be used in respect of goods and services. Then you responded saying no, this cannot be used in respect of goods and services. Then the register of copyright saying no, it's used in respect of goods and services, and hence you have to pay an additional 1500 rupees because you already paid 500. So additional 1500 rupees you have to pay because it can be used, it can be used in respect of goods and services. And also get me a TMC certificate from the trademark registry. So these are muscle flexing things which the copyright office does to get more revenue, maybe. But then again, you have no other option. If you don't comply with the examiner or the copyright office's request, then your copyright application may be rejected. Now, it takes around a year or 2 years to get the objections cleared and the registration certificate to get issued, and that's how a copyright registration process takes place. It's pretty simple, and uh, it's, it's far. So I think I have completed my copyright application process, and we'll go to the next stage, that is trademark registration process. Now, this is a very complex thing, the trademark registration process. It involves lots of strategy, uh, because if you are a big corporation and you want to launch a product with a particular trademark, you have to see the potential customers, which kind of trademark will they use, will they associate the goods to, which kind of trademarks are there in the public which are not similar to our trademark. A lot of strategy goes into this process. Therefore, I'll just go to a little bit of theory while choosing a trademark. What are the things which are necessary? Now, first you have to see what kind of trademark you want to select, that is a word mark or a logo mark or a device mark or a sound mark. Now, word mark meaning, for example, let's take the mark Nike. If you want to file the application for registration of the mark Nike, then you just go to you go for the word Nike, and that's a word mark. If you want to do a logo mark, then the entire Nike with their logo comes, that is the swoosh logo, and that's a logo mark, which is also known as a device mark. Device mark is the picture of the mark. I think it's self-explanatory. I'll just show you some examples so that it's easier. I couldn't have I didn't have much time to make this PowerPoint presentation, and that's why I couldn't. I'll just go to the website. Wait. See, this is the device mark which we are looking at. We call it a device mark. You can call it a logo mark for layman terms. This is a composite mark which also include word and the device. Uh, you can see these are the composite marks. And a sound mark will be the Britannia's jingle, which is a sound mark. Uh, ting, 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 ting. That's a sound mark. If you want to file a sound mark application, then you have to submit a MP3 format audio file. So these are the different trademarks when you are filing for an application or registration of trademark you can consider. Now, going back, the spectrum of distinctiveness is the one which I follow, and a lot of people, a lot of other trademark registration agent and advocates follow, which is to understand what is the degree of the mark, what is the degree of registration of that particular mark is. Now, if the mark is a fanciful mark, for example, a mark which is absolutely unrelated to any goods and services, or which has been invented, it was not there in public and it was it was invented, then it has a very high chance of registration. For example, Kodak or Nike, it was not there. It were not those. These other marks were not there in the dictionary or anywhere in usage. So therefore, these marks had a very high degree of registration. Uh, Arbitrary marks are dictionary marks, dictionary words, which are being used in respect of not similar goods and services, but in respect of different goods and services. For example, Apple computers. Now, Apple is a word which was already there in the dictionary, but it's being used in respect of computers and gadgets, not in respect of apples alone. Okay, so it was not used in respect of apples or fruits. So therefore, this is an arbitrary mark. So you take a dictionary word and you put in an unrelated goods and services. For example, if I take glow, glow is something people associate with skin uh, ointment or creams which you can apply and then you can glow, your skin will glow or something like that. Those that if I apply for that particular goods and services, there is a high chance it not will not get registered. But what if I apply the mark glow in respect of leather belts? There's no problem. Therefore, it's an arbitrary work. It's an arbitrary mark, and therefore there's a good chances of registration. Now, suggestive marks. Suggestive marks are the marks which designate the kind or characteristics of the goods and services you are applying to, or gives an impression in the mind that what the goods and services will be there. For example, it directly not designates the particular goods and services, but gives an impression in the minds of the public that if you are buying the goods of that particular mark, you will be. Uh, Sorry, I'll just take it. Office call. Hello. Yes. Not good time. Hello. So, suggestive work are suggestive mark are those which suggest the possible features of that particular goods and services used under the particular mark. For example, if you're buying a Puma jacket or a Puma running shorts, then you will be fast like a Puma cat. These are the mark which are suggestive. Again, it has a low degree of registrability as compared to the arbitrary mark or a fanciful mark. As we go down, that is a descriptive mark. Again, it has a very low mm, chances of registration. For example, fair and handsome and fair and lovely. These marks absolutely shows and absolutely describes the goods and services which are there going to be used for. For example, fair and handsome is to be used for some cream. Fair and lovely again is used for the cream. So the applicant has to show a lot greater evidence to prove that these marks are registrable, and these marks has gained some kind of name in the public, and therefore it's capable of registration. Now, generic mark is any dictionary word used in respect of goods and services which has similar meaning. For example, you cannot use the trademark salt to sell salt, salty to sell salt. Those kind of marks are not capable of registering as a trademark, and therefore those applications are normally rejected. So as you can see, while we are going down fanciful, arbitrary, suggestive, descriptive, generic, the degree of possibility of registration goes down. If you have a fanciful mark, it's a completely invented mark, then your registration chances are very high. Arbitrary mark, okay, also decent. Suggestive mark, good. Descriptive mark, difficult but possible if you can show use. Generic mark, absolutely not. You cannot use uh, you cannot use the paracetamol for paracetamol tablets. That's a generic. Then your tablet will be termed as a generic tablet. So it is not able to register as a trademark. So go to the next slide. Now, description of goods and services. After we choose a mark, the most important part is how to describe, how to classify the particular goods and services in that order. So what we do, we go to the nice classification of goods and services, and we choose the particular goods which you are going to use in respect of that particular mark. Just go to the nice agreement so that you have further clarity. Nice classification actually classifies the goods and services into particular classes, that is 1 to 45, 1 to 34 being the goods classes, and 35 to 45 being the services classes. For example, if someone wants to register a mark in respect of wines, then we have to rather go to the class 33, that will be alcoholic beverages except beers, alcoholic preparations for making beverages. Now these are the goods which you can include in your application form uh, in respect of the trademark which you want to apply. So accordingly, you have to fill in the description of goods and services, which is very necessary for this trademark application. So you have to classify what all goods you need to have in your registration. For example, if I search Sula, see, Sula has filed this particular application in respect of wines and spirits and liquors. So these are the goods and services description which you need to understand. If I go for an other class of goods and services, for example, let's see Instagram in respect of services, which is in 42. So you can see the goods and services they have mentioned design and development of computer software, providing a website that gives users the ability to engage in social networking. So many things are there. So you have to understand what goods and services need to be there in a particular application. For example, if you want to file a trademark in respect of beers and in respect of wines as well, you have to file two applications. Why? Because 33 is which includes alcoholic beverages, but it doesn't include beers. It includes 32 includes beers or other non-alcoholic beverages, anything. Okay, so if you file an application which includes beer as well as wines, then your application will be rejected. it won't be able to see further light of the day. So you have to be very particular what all goods and services you have to mention in your application, because there cannot be any goods which are overlapping which is overlapping, yeah, overlapping on part of a different class. So if you want to file a class 9 application, you have to mention the goods in class 9, and you can't mention the goods which is in class 42 or 43. If those are mentioned, then the registry will ask you to take it out, or the application will be rejected. So you have to understand, see, the applicant comes to us and say that we have to apply for these many goods and services. Then we have to advise them saying that, okay, these goods are falling under class 28 and these goods are falling under class 29. So you have to file 2 application or 3 application depending on their goods which they want to file an application for. Now, next we have to see whether the mark which we are filing for has the whether it's similar to any other trademark or not, which is there in the registry. For example, I want to file a mark similar to Instagram, then I have to see whether the Instagram mark is readily that particular mark is similar to this mark or not. Let's go to the some other example. Let's see. This is the public search website where we go and we search, we do these searches. How do you access this public search website is go to the ipindia.nic.in website. This is the IPR office's website. It has patents, design, trademark, geographical indications portal. It doesn't have copyright. Copyright has a separate website. Now trademark, you go to the trademark section and then you go to the public search. This is the website where we go to ascertain whether the mark is similar to any other mark which is already existing in the website or not. For example, let's start with the mark landmark. Uh, there are 3 options: start with, contains, and match with. Now start with landmark. If I say landmark, let's do this search landmark in respect of class 35 services. If I do a search of this, see, these are the mark which pops up. Only 33 marks pops up. To make a broader search, we do contains with. See, 46 marks are popping up. You can see which all marks are there which is similar to your mark. Now your mark can be a word mark, or your mark can be a device mark. So it depends which kind of mark you're using. Now there are so many landmark you are seeing right now in the screen. Now all the marks are filed in respect of different goods and services, and therefore some marks are registered and some are not. Which are filed in respect of identical goods and services. The mark which has been filed previous to the mark, yeah, gets the precedence to get registered. Now, if I want to broaden my search, I'll do a match with. See, only some marks are coming, not all. If I want to do a very broadened search, I will do a phonetic search. See, 103 marks came. So anything which is similar to a landmark will come. See, London House came, this mark. Even though it's an abandoned mark, this came. Okay. Now, while understanding which are the marks to be considered in this while you're filing the application, you have to see what are the status of the marks are. For example, this landmark, the first mark, is abandoned. Abandoned means this mark is no longer in the registered trademark list. So might be the mark was registered or not registered, but the applicant who filed this application stopped pursuing the mark or prosecuting the mark at the registry level, and therefore an abandonment order was passed against that particular applicant. Now this mark is registered landmark. That means the mark was filed and it was subsequently registered, and therefore after that renewal applications were filed. As you know, has a trademark has a registration period of 10 years, and therefore the renewal applications need to be filed every 10 years. So here we can see when the application was filed. It was filed on 2nd May 2005, and it was used since 1987, and it's valid up to 2nd May 2025. So it's updated. The mark has been registered for quite a long period of time. Now the next mark, we can go to the status. See this mark. This mark, you can see it's withdrawn. London Rocks, which has been filed by Sotheby's, and this mark has been withdrawn by the Sotheby because they may have filed the application thinking that they would use this particular trademark in respect of goods and services in India. But then Sotheby's thought that, okay, we are not going to expand in India, and therefore why to keep the particular mark in the registry? And therefore they withdrew the application. Doesn't matter whether your mark is registered or not, you can anytime withdraw the particular application. This is also registered. This is a London Olympic mark. Okay, there are other types of mark. See, this is the mark which is opposed. Opposed marks are those marks which has third party oppositions to them. You have to understand that there are two types of oppositions which comes to to a particular mark. One is objection and one is opposition. Now, objection comes from the registry side and opposition comes from the third party side, like any random party who can oppose your mark. So right now this mark is opposed. The title of the mark, the name of the mark has been opposed by a third party, and therefore the opposition proceedings are pending for this mark, and therefore the mark is currently not registered and is opposed. So these are the different status of the mark. I'll show you one more status that might. See this mark. This mark is refused. The applicant filed the application and the registration did not take place, and because there was some problem and the mark was refused. So therefore the status is shown as refused. Now some marks will be objected. See, this mark is objected. The status of the mark shows objected. Therefore, the application has been filed and the trademark registry had objected the mark, and right now it's in the examination stage. This mark is accepted and advertised. That means the objection has been cleared and now it has gone to the advertisement stage. We'll go to the different stages later. Okay, this shown as formalities checks pass. If you can see, this is formalities check pass. That means the application has been filed and the basic formalities, which is the registry check whether the application is proper, in order, does it have all the necessary things which is required to be filed along with the application. Those are the things they consider. Now it has passed those formalities and therefore it's shown as formalities check pass. Next it will go to the examination stage. Now why the statuses are important when you are doing a search in the online registries records to ascertain whether your mark is similar to any other mark, because see, the mark which are refused, abandoned or withdrawn are not to be considered for the purpose of your searches, because those are the marks which are not in the registry, so they will not come and file any oppositions against us. So this particular trademark searches is required to be able to be prepared for the future if there's any third party oppositions. We want to avoid as much as problems as required, because even though we will take abundant precaution to file such a mark which is not similar to others, still somebody will come and say, no, 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 this mark is similar to mine. For example, I think the Covaxin vaccine of this COVID-19 was also been opposed by some person. I just go to this. Some was opposed. See, all are accepted and advertised. See, if they want to sell those uh, vaccines, they have to market it under a particular trademark. So wherever you go, doesn't matter if you are in medical line or something, everything comes with a trademark. See, so many people has filed new applications for COVID vaccines. So you can check from the registry's website who are the interested parties. I'm not able to find the exact particular trademark which has been opposed to show you why it has been opposed. So these are the things which you need to consider before filing the application, because if your trademark is very similar to the other marks, then there is a higher possibility the trademark registry will issue an examination saying that no, 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 your trademark is not going to get registered, and therefore it's liable to be refused. And then you have to clear those objections. If you are not able to clear those objections, your trademark application will get refused. If you are able to clear the objections, the trademark will pass an order of acceptance and advertise the mark in the trademark journal. If the trademark journal, any third party comes and see your mark, "Arey, ye to mera mark hai," or is it similar to my mark, that person will file an opposition against my mark. Then it will go to the opposition stage. So this public search is very, very necessary to anticipate what kind of problems will be there in future if your mark is similar to other mark, or to ascertain whether your mark is similar to other mark. If it's not, great. So public search is very, very necessary. So when an applicant comes to you, or a person who wants to file an application for registration of trademark, we need to do a prior search, people say prior art search in patent. And we do a prior public search in the registry's website to ascertain whether the mark is similar to other marks or not. Now, coming to the next part. Now, after ascertaining whether the trademark has a similar trademark or not, we have to ask the client whether the mark has been used or not. Why it's very necessary? Because, for example, if you have a landmark mark which has been used since 1999, okay, and you want to file an application in respect of the services falling under class 35 only in the year 2015, okay. Now there might be any other mark which a third party has which some other person has applied in 2005, which also has the mark landmark in it. Then there will be a problem. So if you file a 2015 application subsequent date, your mark is likely to be refused, because there is already a mark which has landmark in it. So therefore we have to ascertain whether we have a prior right in that particular goods and services. For example, then we have to claim use, that we have been using the mark since 1999. We have the common law rights over that particular mark. People know us. The mark is distinctive, and therefore you have to give me the registration. This is very important. If the mark has been used, you have to claim the use. It will be a foolish of a person if he doesn't claim the use of a mark which has been used at the time of filing the application. If the mark hasn't been used, it's proposed to be used, because at the time of the filing of the application, these are the details which need to be answered, which needs to be asked. where the registry asks in the application form that the mark has been used or not. These are the things. See, if the mark has been used, then you have to prepare a user affidavit to claim use in that particular mark. Under the trademark rules 2017, a user affidavit is mandatory to be filed in respect of a trademark application. While filing a trademark application, or else the mark will, you cannot claim use in the mark. You have to file a trademark user affidavit. Earlier to 2017 rules, when we have 2003 rules, that times, sorry, 2000 rules, trademark rules, that times, you, even if you file an application claiming use, it was not necessary to file a user affidavit, and that was a loophole in the trademark rules, and it was corrected by the trademark rules 2017. There you have to file an application with the user affidavit if you are claiming use. That is mandatory. So affidavit, a normal affidavit needs to be made where you have to show that this mark has been used since this date. This is the invoices. See, to prove that the mark has been used, you need supporting documents to show. For example, the landmark has been used in respect of medicine. So you have to show the sales figures. You have to show the, either you have to show the sales figures or the annual reports or the photographs or the correspondences or the purchase orders or the sales invoices, anything which includes the mark and the corresponding date when that particular document was published. Because unless the corresponding date is there, how can you prove that you have used the mark since that date? Okay, so the affidavit contains those things. I'll just get you through one affidavit to show you further. So let's go for Nike, Warner Brothers, in respect of services containing in class 41. Nothing is there. Wait. Thing is coming. Wait, let's do Instagram only. See, if we go to the registry's website, the trademark, it's not available. I don't know what's the problem. So we have to go to the e-registrar's website to determine whether the mark is registered or not. Wait, I'll just show you one affidavit. So this is the application which we file. This is a format of a normal application. See, this is a filed application. This is where we enter the nature of the trademark application filed as others. This others meaning who are the, what is the class of the good applicant that is being, whether, sorry, whether, what is the what is the type of the legal entity who is filing the application. For example, if the applicant is a sole proprietor, then the application, the fee charge will be 4,500 and not 9,000. And if the applicant is a company, then the fees charge will be 9,000. If you're filing through online, then there will be a 10% reduction of the fee, or else the application fee will be 10,000. Similarly goes for the individual. If the application is through online, it's 4,500. If it's physical, it's 5,000. So here's the name of the applicant. That is the Good Drop Wine Cellar. This is the address. This is the jurisdiction. This is the address for service. The address of service is required. Applicant's agent name, address. This is the mark which needs to be applied, trademark. Now, this is the class, that is wines and alcoholic beverages. The statement as to use of the mark has been used since 8th March 2016. Therefore, when we are claiming use, then we have to furnish a user affidavit. This is the user affidavit. This is the type of, everything is available online. That's why it's very easy to show to you guys, or else I wouldn't have shown. Power of attorney. This is the power of attorney which we require to file along with the application, because otherwise how will the registry know that we are authorized to file the application? This is the affidavit. This is the affidavit of a person who is the director of the company, who is claiming that the mark Rio Spritzer has been used in respect of goods and services since 8th March 2016. The 8th March 2016 is the date which we have mentioned in the top. If you see 8th March 2016, this is the date we have mentioned in the top. So we have to actually mention the date. Now, after that, we have said, okay, these are the annexure A, that is the print copy of the online set of the register. We have to attach some annexures as well to show use of the mark. See, the applicant has been using since 8th March 2016. Annex Tier 2 and marked as Annexure D is a redacted copy of the invoice dated 8th March 2016. Why do we use redacted copy? Because we cannot show private information, because it's a private limited company, to the public, as the trademark application and everything relating to the trademark application is available online. You have to be very cautious while showing any documents of a private limited company. So if you go to the annexure B, C, D, D, see D, we have the date 8th March 2016 and the mark used. Rio wine. These are the marks which are used and we are claiming use. There are subsequent users, see Rio Spritzer. See, the marks are there and the date is also there. So two things are very necessary: the mark and the date, which needs to be there in the trademark user affidavit. Now going back to the PowerPoint. After claiming the use, we file the trademark application. Now the trademark goes to an examination stage. So sorry, before the examination stage, the formalities checks are done. That is, the trademark goes through again, whether the trademark application is proper format, if the user is claimed, whether the user affidavit is there or not. Now, as due to digital application process, if a user date is claimed and a subsequent user affidavit has not been submitted with the registry, the application would not be the application would not the trademark registry office would not allow you to file the application only without the user affidavit. The application the process will stop there. So if you claim a user, you have to file an affidavit. So all the required things are there or not. Power of attorney is very important. If you're filing as an advocate or an agent of the trademark agent, then you need to require a power of attorney from the applicant. If the power of attorney is not there, the application will not allow you to proceed further. Now, after that, examination stage comes. So normally when an examination stage comes, the registry raises questions as to the registrability of the trademark. That's why this is important. whether the mark is fanciful, arbitrary, suggestive, descriptive, or generic. Because if you have gone through this process, then you know what kind of objections the registry will give you. The examination stage, the registry either raises an objection under section 9 or under section 11. Now section 9 objections are raised in respect of the mark being very descriptive or being generic, whether the mark is liable to be rejected or not. If you can read section 9, you'll understand what are the different types of objections which are being raised by the registry office. And if it's a section 11 objection, then it will show you what are the different trademarks which are there in the registry, which is similar to your trademark, and therefore this your mark is not liable to be registered. I'll just show you one examination report to give you a further clarity about the situation. uh, See, this is a typical examination report which has been issued. This is the application number. This is the name of the applicant and the class. See, the examination report has been issued. The objection has been raised in respect of section 9(1)(a) of the trademark, as the mark is non-distinctive and as such is not capable of distinguishing the goods and services from those of the other persons. There's one objection. We have to clear that objection through our examination report. Subsequently, there is one section 11 objection of the act. That is because the same or similar mark is already on record of the registered for the same or similar goods and services. The details of same and similar trademarks is enclosed herewith. Now, what are the similar trademarks? They attach a list, and these are the similar trademarks. So if the mark is 99%, the similar trademark according to them is this. Okay, we can't see what is the trademark here. They haven't shown the mark. Normally they attach the image of the mark. Mostly, if I'm not wrong, this was a mark which the mark name was 99 cent. So then we have to, in our examination response, the report response, we have to show why the mark is not similar to that mark and why section 9 objection is also not to be considered. We have to give reasons, we have to give judgments to show that okay, the examination report which has been issued to this particular trademark application need to be set aside. Okay, and this trademark application need to be processed as fast as possible. So once an examination report is issued, trademark and the same is being served on the applicant, we have total 30 days of time to respond to that particular report. Examination report gets issued and the response needs to be filed within 30 days of the receipt of the same. If you don't file the response within 30 days, the mark gets abandoned. Now, I've crammed so many points here, so please be very attentive to what I'm saying. Now, once a response to the examination report is being furnished to the registry, the registry goes to the content of the same and decide whether the mark is actually acceptable for registration or not. If it's not acceptable for registration, they schedule a hearing. Now, the hearing can be scheduled for 3 times. So you have 3 opportunities to clear out your application. So, for example, if the mark is accepted, then it will directly go to the advertisement stage. If it's not accepted, it will go to the show cause hearing. Now, show cause hearing is where you again go to the registry's website and do your oral submissions. In the response to the examination report, you have done your written submission in support of the application for registration of the trademark. In the show cause hearing, go to the registration office, that is the trademark office, and you show why as to why the trademark needs to be registered. Okay. Now, why this is the two processes given, because there may be some additional points you want to make which you couldn't able to make in the examination report. Also, examination reports and examination responses are issued and scrutinized respectively by examiners and not senior examiners. Senior examiners are those people who goes for the show cause hearing. They have more experience in the matters, and therefore there's a high chance of getting the mark registered. And also it's a entire process. So most of the time, around 90% of the application which gets examined goes to the exam show cause hearing stage. That is, you have to appear before the particular hearing officer in the registry's office, and you have to clear out the uh, objections which was there in the examination report. Now, you have three chances. If you are unable to do that, your mark gets refused. If you are able to do within that period, your mark gets advertised. Now, advertisement stage is for 4 months. The trademark accept the application, issues an order of acceptance if it's in the hearing stage, and if it's in the examination report stage, the acceptance can be done through an order. Now, in three stages, acceptance order can be passed. One, at the time of examination. When the examination happens and the trademark registry sees that there is no problem with the application, we pass an or acceptance order. If mm, the examination happens and we file an examination report, we clear out the objections, they pass an acceptance order. If it goes to the hearing stage, then they pass an acceptance order if we clear out the objections through our oral submissions. Advertisement happens next. That is, after acceptance, 4 months, the trademark application gets advertised in the registry's website. So a journal is issued in which the trademark gets advertised. I'll show you the copy of the journal. Uh, okay, trademark registry website can be a pain. It's very slow. This is the second busiest website after, no, third busiest after IRCTC MC. Still loading. Anyway, the mark gets advertised in the trademarks journal, and thereafter you have one, if any third party wants to file any opposition to that particular mark, they have 4 months of 4 months period to file a particular opposition. You saw when the mark when I was when I was showing you the marks in the public search website, certain marks were opposed. So those marks were opposed in that particular 4 months period. Somebody filed the opposition and said, no, 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 this mark is similar to my mark, and therefore this application need not to be registered and ought to be dismissed. So a notice of opposition is filed, that is in form TMO. Once a notice of opposition is filed within the 4-month period, the registry then serves that particular notice of opposition to the applicant. Now, who is filing? The person who is filing the notice of opposition is called an opponent, and the person who is the other person is, of course, the applicant. Now, the applicant, once he receives the notice of opposition, he or she has 2 months of period to respond to that particular notice of opposition with a counter statement. Now, the counter statement needs to be filed within 2 months or the application gets abandoned. That you are not interested in the application. When after a counter statement is been filed, the registry serves that particular counter statement to the opposite side, that is the opponent. When the opponent receives the counter statement, again he or she has 2 months to respond to that counter statement with an evidence in support of opposition. If the evidence in support of opposition is not filed within 2 months, then the opposition gets abandoned. This time not the application. Now, evidence in support of opposition, the opponent has to file with the registry and give a copy to the applicant. The registry will not give a copy this time. Now the opponent needs to give a copy. Once the opponent gives a copy to the applicant, on the receipt of the particular copy, the applicant has 2 months to file the counter statement. Sorry, evidence in support of application. The applicant then, if he or she chooses not to file the evidence in support of application, the application gets abandoned. If he or she files an evidence in support of application within 2 months of receipt of the evidence in support of opposition, then the opposition period continues. Upon receipt, again the applicant serves the affidavit with the registry, files the affidavit with the registries, and along with gives a copy to the opponent. On receipt of the copy of the evidence in support of application, opponent has 1 month time to do an evidence in reply in support of opposition. Now, this is a optional thing, which if not filed by the opponent, will not deem its opposition to be abandoned. So, opponent has this option whether to file or not file. It's simple evidence act. That is, once you do a examination in chief, the other person do an exam cross examination, and then the other person has a chance of rebuttal. There is no sub rebuttal. Sub rebuttal is only there in moot court competitions. Okay. Now, once that is done, you have a hearing stage. Now the pleadings are completed. Now this matter goes to the hearing stage. Now the trademark registries in India are very slow to post matters for hearings in opposition matters. We are right now clearing out matters as old as 10, 15 years. The foreign clients are asking 15 years, there is no registration. What is this? We have no answers to give because the registration office is very slow. Mumbai especially has so many matters that the opposition period takes a lot of time because the opposition hearings are taken by very senior officers. Those are deputy registrars, those are additional registrar and assistant registrars. So those people have other administrative works in the registry and they don't have that much of time. So when they start clearing out matters, and once a hearing date is posted, after that, if that hearing date you couldn't complete your matter, then another hearing date will be posted after 1 year or 6 months. Okay, so again you have 2, 3 hearings or 4 hearings depending upon the mood of the particular hearing officer who is the additional or assistant or the deputy registrar of that particular trademark office. Now, depends on the registries. Ahmedabad and Chennai registries clear out opposition very faster as compared to Mumbai office. Mumbai office hearing takes place over like 5, 6 years. So you have to be very careful and very proper when you are doing the public search and you're issuing a search report to your client at the time of filing of the application, before the filing up of the application. Because once your mark gets opposed, you're stuck. Unless you settle the mark, you settle the issues with your opponent and you go for a settlement. For example, you have filed your application in respect of goods falling under class 41 in respect of school, entertainment, everything. Your mark is universal. For example, Universal Studios comes and says, no, you cannot use the mark universal because we are a prior user of the mark universal. We have prior rights, we have prior common rights, we have an established trademark. Our mark is well known to the world. How can you use universal in respect of entertainment? So that the applicant say, okay, fine, I'm using for school. We also have a good established reputation for 10 years. I'm going to use the mark only in respect of schools. I'm deleting the entertainment part. That applicant will file if the opponent, that is the Universal Studios, is amenable to that request, then the applicant will file a amendment application and will delete that particular goods and services, that is the services, that is the entertainment. And then the opponent will say, okay, fine, I'm cool with it. If the registry has accepted your amendment application, then I'll file a withdrawal of my opposition letter, a letter of withdrawal of my opposition. So it's much faster if you settle the matter. If in an opposition stage, if you are unable to settle the matter, and if both the parties want to contest the matters, then it will go a long stage, 10 years. Aram se. Now, if nobody files an opposition, and your mark gets advertised, and your mark is now registered. Because after 4 months, if nobody files the opposition, your mark gets registered. A registration certificate is issued, and the date of registration is the date on which you have filed the application. Mind it, if you filed the application in 2011 May 23rd, and your registration is on 15th August 2016, then your application, the registration certificate will show 23rd May 2011 as the date of registration, and not 15th August 2016. 15th August 2016 is the date when the registration came into force. I'm very sorry. The registration certificate is issued, not the date as the date when the registration came into force of the particular trademark. The date of registration is always the date when you file the application. Okay. So sometimes the opposition goes for 10 years, and the 10-year period of the registration withers away. For example, if I file the application in 2011, if I filed the application in 1999, and the opposition hearing is happening in 2017, for example, I've cleared some of these opposition like that, of foreign clients, domestic clients, a lot of them. Then when you get a registration certificate, you get a registration certificate on 2017. Your application was filed in 1999. So you ought to have renewed the mark after 10 years of filing the application, because the registration is valid for 10 years. And if the application date is counted as the date of registration, then the trademark should lapse after 10 years. So the registration only happens after 10 years. Then what did you do? You have to file a renewal application immediately after the issuance of the registration certificate. If you don't file, you have a 1-year period. After that, your mark will be taken out of the register. So this is how a registration process takes place of a trademark. Okay, and next we'll go to the rectification process. Now, when I said registration certificates gets issued in after a period of time, and the registration date is always the date when you have filed the application, the registration certificate also has another date, that is the date of issuance of the registration certificate. Why that is necessary? For example, you have applied for a mark. Again, let's take an example of for example, classmate. You have applied for the mark classmate in respect of goods falling under class 16, that is notebooks and everything. But you have filed the application for the mark classmate in 2002 as proposed to be used. You have not used the mark at all. Now, classmate in that particular class received registration after 4 years. That is 2006. Now, if a third party comes and say, okay, this registration is not proper, third party may be the person who is interested in that particular mark or has been using a mark similar to that mark, and who was unable to file an opposition at the time of opposition stage, at the time of advertisement when the mark was advertised. That person will come and file a rectification application saying that when the mark was entered in the register, one second, just 5 years have passed since the mark has been entered in the register and the mark has not been used. 5 years has been passed since the mark has been entered in the register and the mark has not been used. Therefore, this mark is liable for rectification. So the time which will be calculated is not from 2002 but from 2006 if the rectification application they wants to file in 2012. They will say the mark has been in register for 5 years. Because before that time, the mark was not in register, even though the registration date is of 2002. The mark came into registration only 2006. Registration date is always the application date. But the mark came in 2006 into the register and the mark hasn't been used for the last 5 years. Then that will be a ground for rectification. Or the mark is improperly in the register and is a word which is a mark which is very generic, which is very generic to the dictionary, generic to the goods which are being used for the mark. For example, again, salty for salt, but somehow the trademark registry overlooked it and gave a registration, and the person who has filed the rectification application wasn't able to file the opposition at that advertisement stage. He will say that that mark doesn't deserve to be in the register. Therefore, a rectification application needs to be filed. The mark need to be removed from the register. Then a rectification application in the form TMO will be filed. That is a post-registration thing. All the points which I mentioned, rectification, assignment, license, registered user, cancellation, renewal, are post-registration. Even though license and assignment can be filed pre-registration as well. Now, I'll take you through some forms to make you understand what are the licenses. Before that, I'll just explain the assignment part and license part. See, assignment of a trademark is transferring title to use the complete use of the title along with the goodwill of the trademark to a particular person. For example, A has been using the mark Instagram and B said, okay, I'm buying your company, but just buying your company would not do any favor to my business. So you have to give your mark as well. A is like, yeah, of course, if you want to operate the business which my company has, you have to use the mark also. Now the mark which has been used in respect of the particular business need to be transferred along with the goodwill in respect of the particular business to B. This assignment gets recorded in an assignment deed, deed of assignment of trademark, which again comes with a stamp duty. Now stamp duty differs from state to state. The stamp duty will be on the consideration paid for the particular assignment. For example, the mark Instagram has been sold to the other company, has been transferred to the other company in consideration of, say for example, 40 crores. So the percentage of the stamp duty will be calculated on that 40 crores. 40 crores stamp duty, that is, for example, in Maharashtra it is 3% of the consideration amount. So 3% of the 40 crores you have to pay a stamp duty to the Maharashtra Treasury. It's in Karnataka, it's 0.02%. It's very good to make a deed of assignment in Karnataka because the stamp duty is very cheap. That's why a lot of company pops up in Karnataka. Now, once you do a deed of assignment, you have to file the deed of assignment with the registries. Or else, how would the registry know that you have an assignment of trademark and the mark is now not with company A but company B? You need to file an application for assignment of trademark. Okay. That application again need to be filed along with a no court proceedings affidavit. No court proceedings affidavit is required to prove that there are no pending litigation between company A and company B with respect to the title, sorry, with respect to the assignment. If there is a problem, then the registry is not going into there, and they will say that no, assignment nahi hoga, sorry. You first settle your problem, then will come to me and we will do the assignment. So you have to file a no court proceedings affidavit along with the deed of assignment with the registry to assign that mark. Now, an assignment is different from a license. How? An assignment gives you complete rights to that particular trademark, the title to the trademark. In the name of the trademark registry, in the name of the applicant, your name will be mentioned. If the application is pending, then you will be the applicant. If the application is pending registration, then you will be the applicant. If the trademark application is registered, then you will be the registered proprietor. Now, registered proprietor, a license is given. Sorry, a license to the trademark. Now, I've talked about assignment. A license to the trademark is different. There, you give only certain rights to use the particular trademark to a particular person. For example, I have a mark Fenner. I'm a company of US, and I said I'll not open a new company in India. I will I license the mark to a different company who will use the mark and do our business there. But will not relinquish the rights, the complete rights to the particular mark, that is Fenner. So I'll not do an assignment of trademark. I'll do a license of trademark. You have to pay a license fee and then now license of trademark need not to be registered with the registry's office. You can execute a normal license and you can keep it to yourself. But if you want to get it registered with the trademark office, then you have to file a form for registered user. Now that form needs to be filed by both the company, the licensor and the licensee, to show the registry office that in addition to the licensor, the licensee also has the right to use that particular trademark in the territory of India. Now this is a license and an assignment. A cancellation of trademark is, for example, HDFC Standard Life, for example, I'll take. HDFC Standard Life, recently, the Standard Insurance Company exited the company. So all the trademarks which HDFC Standard Life had, like most of them, had the mark Standard in it. Now they want to exclude the mark Standard because right now Standard has left the company. What will they do? They can either rectify the trademark, they can file for an amendment application for the trademark, but that is not plausible. Nobody gives an amendment right to a trademark. Like the registry will not allow you to amend the trademark. Once an application is filed, khatam. Now, what is the other option? You can cancel those trademarks. Registration cancel kar do. Nahi chahiye. Then the status will show cancelled. You can file for a cancellation of this trademark. Renewal, every 10 years, you have to renew the mark. If you are unable to renew the mark, you have a grace period of 1 year. First 6 months, you have to pay an additional 50% to renew the mark. The next 6 months, you have to pay an additional of, you have to pay 100% charge, surcharge to renew the mark. For example, to renew the mark, you have to pay normally 9,000. If you have failed to renew the mark within 6 months of the last date of renewal, you have to pay 9,000 plus 4,500. Within 1 year from the last date of renewal, you have to pay 9,000 plus 9,000. If you are unable to do both of them, the mark is liable to be abandoned. Then you have to file an application for registration of the trademark. You have to show why you have failed to renew the mark. Now, the registry is bound to issue you O3 notice at the time of renewal of the mark. Right now it's RG. If they fail to issue that notice and you are somehow missed the renewal date and didn't renew within 1 year also, then the registry cannot abandon your mark. You have a cause of action in the court of law, district court or high court, which will have to reverse the registry's order of abandonment because it was registry's fault they didn't issue your O3 notice. What is an O3 notice or RG3 notice? It is to notify you that your mark is going to get lapsed and you have to file the renewal application. See, normally after 10 years of a mark get registered, most of the applicant will forget the mark. Arey, file ho gaya, khatam ho gaya. Then he needs to get reminded, because a trademark application can be filed not only by lawyers but normal lay person also. So lay person will not keep in tabs like acha 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 khatam ho gaya. So registration khatam ho gaya. So he has to get issued that particular notice to let him know, or her to know that okay, my registration is getting expired, so I have to file. If the registry is unable to furnish that notice, you have a plausible cause of action against the registry that okay, you cannot remove my mark. You have to reinstate my mark. Okay. So this is the entire trademark registration process and supposed registration process of trademark. I'll just let you through some forms of the trademark registry to make you understand further.
So, before you proceed, would you like to take a few questions? Because we have received quite a few of them.
Sure, I can take.
So, Shravya,
Yes, ma'am. So the first question is, can we use or register abandoned trademarks?
Yeah. See, that trademark is a private right, and also it has a territorial jurisdiction to attach to it. Now, a mark which has been abandoned, for example, landmark in respect of goods falling under class 21, somebody had filed that mark long back. Mr. A has filed that mark, and Miss B wants to file that particular mark again. The registry will raise this question: listen, this mark has already been abandoned. Why do you want to file? Then you have to show the registry the plausible reasons why your mark needs to get registered. Listen, no, my mark is a device mark. I have not applied for a word mark. Word mark got abandoned because it's very generic or whatever. My mark is a design mark. I have artwork in my mark. It has distinctive elements in it, which distinguish my goods from any other goods from the market. And I've also used the mark since 10 years. So I have a common law right on that particular mark. Hence, this needs to be get registered. So you have to show the reasons for registration. You have to quote the particular judgments for registration. Okay. Even though, see, there is no straight jacket formula that whether a mark is similar to not. For to me, this mark is might not be similar, but to person Z, this mark be similar. So the examiners who are examining the examination reports, this is not one examiner. They have given they have been provided with a workshop as to which mark is registerable and which mark is not. But for example, one examiner issues you an examination report that okay, landmark mark is abandoned. Why you want to register the mark? It's but the next examiner says, "अरे नहीं 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 कुछ problem नहीं है. This mark has already been abandoned. So this person wants to adopt this mark. Why not? There is no other person in the class. I'll give it to him or her." Next question.
The next question is, what is the length of the term of trademark, or how long does a trademark last in India?
Trademark has a 10-year period of registration, as I told you. After 10 years, you have to renew it. It can be renewed any number of times. N number of times it can be renewed. That's why there's a recent trend in the trademark industry. You can see on trademark law, sorry, not industry. Across the world, the trademark registration mostly has a 10-year period, be it in US or India or UK. I'll give you the prime countries. Now, what these big corporations are doing, they are registering their artwork as a trademark. For example, Disney has registered Mickey Mouse as a trademark. Mickey Mouse was previously subject to copyright. Now, Mickey Mouse was created like long back, 1920 or 1930s. The copyright subsists for 50 years in US. 50 years got over. Copyright office said, no, no, you don't have any further rights. You will go to public domain. Just like Rabindranath Tagore's work are in public domain. Anybody can use, anybody can exploit, because 60 years have passed after Rabindranath Tagore died. So Disney said, no, no, no. Even after Walt Disney's dead, we have 60 years time. So the copyright office says, okay, fine. But 60 years is now 50 years. 50 years is now over. What will you do? The copyright office went ahead and registered the Mickey Mouse as a trademark. Nobody can use now Mickey Mouse. They will keep on renewing the trademark, renewing the trademark, renewing the trademark. N number of times. This is a new kind of trend. Another new kind of trend is registering your name as a trademark, personality rights. For example, Messi, Ronaldo, they have registered their name as a trademark. Messi got his registration. Nobody can use Messi in respect of that particular goods and services. And even if anybody else wants to use in respect of wine, they'll say, no, 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 this is very famous mark. You cannot use. I'll file an opposition. I'll file a suit for infringement. If it's a well-known mark, you cannot file an application in any class. For example, Apple. You cannot use Apple for anything. Apple wines. Everybody will associate that particular wines with Apple computers. Oh, Apple computers are in the wine business. No. Somebody else has launched the wines. Apple is so famous, well-known mark, you cannot file an application in any other class. Similarly, there is another trend of registering the picture of the monument as a trademark. Two very important people in a company has registered their trademark, their monument as a trademark. One is Bombay Stock Exchange and one is Taj Hotels. Taj Hotels have registered their iconic Taj building as a trademark. Nobody can take a picture and publish it on a t-shirt, because there's an order. No, 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 you are infringing our trademark rights. You can take a picture, you can use it for your own purpose, you can post it in Instagram and Facebook, but no, you cannot use it on a t-shirt and sell to public. That's our right. They have registered the photo of the entire architecture, the photo of the Taj, the Mumbai Taj Hotel as a trademark. Bombay Stock Exchange has registered their Dalal House, that BSC, that iconic building, as a trademark. Nobody can use it as a photo on a t-shirt or use it as a key pendant on a key pendant or as a chain or as a key ring. Nobody can use it. They'll face an action of infringement of trademark. Now it depends how many goods, classes and services they have registered the trademark into. If they have not registered in respect of class, in respect of wines, they might have a right. Okay, I can use Taj, but again, Taj is very famous. If somebody uses Taj in respect of wines, then Taj Hotels will object. No, 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 my mark is well known. How can you use? Even though I don't have a registration in that class, I have an actionable rights there. I hope this answers your question. Next.
The next question would be, do the publishing houses who publish old stories like Sherlock Holmes of author Conan Doyle hold copyright in same, or is it stories available in public domain?
Arthur Conan Doyle long back. So Arthur Conan Doyle, after the death of Arthur Conan Doyle, the copyright in those works rests with the publisher who has the rights on that work, or with the estate of Arthur Conan Doyle for 50 or 60 years. After that, now it is in public domain, just like Rabindranath Tagore works. Everything is in public domain. Recently, 2 years back, Amitabh Bachchan did a furore. Why there is a problem with the copyright? There is a problem with the copyright law that after 50 years of passing of my father, I have to 60 years of passing of my father, I have to relinquish all the rights to his work. He started ranting in Twitter and Facebook. Why? Against the copyright law. Nothing will happen. This is the law accepted by the entire world. He wants to take economic, he wants to take profits of his father's work till now also, even after passing away of his father. 60 years of passing of his father. So after 60 years of the death of the author, the copyright subsists with the person who has the title to that particular work. For example, the publisher or the estate of the person. Here in this case, Harivansh Rai Bachchan died long back after 60 years. In that particular period of 60 years, Amitabh Bachchan has right to his work. He had only the right to sell the work of his father. Now 60 years has passed, everybody can use. It's in public domain. So that's why Amitabh Bachchan became angry. Next.
If I have got a trademark and there are hundreds or thousands of people filing for a trademark in a day, then how do I come to know whether any person applied for a trademark similar to mine? As I can't keep watching every single day to file for an objection.
Absolutely not, you can't. It's a very good question. But I remember, it's a personal experience, landmark, which I was saying. Landmark is a mark. I filed for an application of the word mark landmark in class 35. There were thousands of trademarks already registered, not registered, either registered or objected or opposed or abandoned in that particular mark, in that particular class 35. But not a single objections were raised by the trademark office to my landmark application. There are certain reasons to it. One, my mark, when I devise the goods and services, I use such language to connote that my mark has been used in respect of particular goods and services, and hence it's very different to the other trademarks which are landmark in that particular class. Landmark somebody may be using for construction, somebody may be using for something else, insurance, but I have used only for this, and nobody else has prior rights to other than my rights. For example, I have used in respect of car showrooms, and no other landmark is there who has used in respect of car showrooms before me. I've used since 1998. Show me someone else. So you have to structure your user affidavit in such a manner so that it is robust, and the trademark office will not even raise a question. It took me one entire day to make a user affidavit. It should not take you one entire day, because the user affidavit was need to be extensive with good evidence, like this is other report, see landmark is mentioned since 1998, 99, 2002, 2003. Your case should be proper before the registry. They accepted, but then some random idiot filed an opposition. Chuck it. We'll clear it out. See, you cannot anticipate each and every action. It's a game of chance when you are filing a trademark application. More so if you are filing in the pandemic period, because right now lawyers are making money through opposition processes. Therefore, till the date you are issuing a trademark search report and an advice to the client that okay, this is the class, this is the trademarks which are similar, it's better you file the trademark application which within a short span of that report, so that there are no other applications getting filed in the same class. Okay, like you cannot be humanly impossible. For example, I'll just tell you, there is a mark Fair and Lovely, everybody knows, bad thing. So what did Hindustan Unilever did? They changed it to Glow and Lovely. They also filed an application for Glow and Handsome. Imami came running. Imami said, no, I have prior rights in the mark Handsome because I have been using Fair and Handsome. You have been using Fair and Lovely for men. How can you file Glow and Handsome? What did Imami do? Imami immediately launched the mark on 26 June. 27 June, they filed an application. These things can also be happening. They filed a Glow and Handsome application. Said, no, we have launched, we have prior rights. The Hindustan Unilever launched with a proposed to be used claim. Imami said, no, we have used it. They filed it within 2 days of launching that particular Glow and Handsome by HUL. So there are different things which happens in a real life situation. Once you get into practice, you'll understand. The more you brush the trademark law, the more insight you will have. the more experience you gain in this industry, the more insight we'll have. Next question, please. Hello.
Yes, sir. The next question would
Huh.
be, well-known marks are recognized based on their duration of usage or extent of public recognition.
Both. Now, somebody is using the mark FCV since long. I'll give you an example. Toyota wanted to register the mark Prius in India. The trademark got accepted, application got accepted, and they were given they proceeded to registration. But someone called Prius Motor Parts objected, saying that no, we have a prior right in it. They filed a suit for infringement. Delhi High Court, when taking up the matter, said no. Trademark is a territorial right. So if Prius motors are prior to you cannot have a trademark registration in Prius. Prius you might have introduced in Japan, but Japanese people know of your trademark, not Indians. Indians knows about Prius trademark. So you cannot claim that it is well known in Japan and therefore I know. They claimed, Toyota claimed Prius is a well-known mark and therefore we need to have a right to use the trademark. They were denied. Now, well-known, the ability to being a well-known mark depends on a lot of factors. It also depends on the transnational factors that the trademark right, the well-known or distinctiveness of the mark spills over the other jurisdiction. For example, Pepsi was introduced in India in 1970 or 80 something. But before that, Pepsi was already famous in India because through television and all we used to see. Sorry, that time there was no television, but radio and all we used to hear about the word Pepsi. Now, for example, H&M recently came to India. Before that, H&M was also already famous in India. So anybody who will file an application for H&M will immediately come from Sweden and say, no, 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 you can't. Our mark is well known. They will prove that we have a transnational right. Our right has spilled over jurisdiction, even though trademark is a territorial right. So well-known has a lot of factors to be recognized as a well-known. Need to be used for a long period. Need to have large sales to actually show that it's a well-known mark. It's known to public and the traders alike. For Apple, for example, nobody can use Apple except them. Nike, nobody can use Nike. Puma, nobody can use Puma, even though they are in the sportswear segment. Nobody can sell a Puma azithromycin and say, no, no, this is my azithromycin tablet. And Puma is not in the same class. No, you can't say. But again, there are other judgments. Trademark law is a case-to-case basis problem. Raymond Pharmaceuticals, some random company pharmaceuticals opened their shop as a name Raymond Pharmaceuticals. Bombay High Court held as Raymond Limited has no business in pharmaceuticals. Raymond Pharmaceuticals should be allowed to continue in the business. And Raymond pleaded that no, our mark is well known. They are harping over, they are using my mark to for their gain. Then the Bombay High Court said, no, Raymond is a common word. And you have only well-known, you have only fame in the garments area and not in pharmaceutical business. Now the appeal is pending. Anyway, so well-knownness of a mark depends on a lot of factors, and to be classified as a well-known, you either have to file an application to the registry, giving 1 lakh rupee, or you have to go through the litigation process where the court recognize your mark as well-known. So it depends on a case-to-case basis, and there is no straight jacket formula for it. Next question.
What are the obstacles to smell mark registration in day to day practice? How does one represent smell marks in visual ways, etc.?
Excellent question. I have not dealt with spell marks so far, but there's a certain smell. If you see the Oriflame catalogs, you will find smell marks. I'm so sorry, I am not able to answer this question because I have not faced that kind of situation in day-to-day public, because we normally deal with logo and word mark a lot more. There has not been much jurisprudence in smell mark in India. Uh, Sorry, thank you. Next question.
Will there be any preliminary inquiry or hearing before registrar while granting assignment or approving the assignment form?
So when assignment and application has been filed, assignment application gets filed in the registry's website. Of course, every application goes through scrutiny. If the stamp duty is not proper, they will raise a query. Then you have to say, no, 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 stamp duty is proper. Or if it's not proper, then it's liable to be impounded, because it's an instrument and the stamp duty has not been paid. If you have not filed a no court proceedings affidavit, they will ask for a no court proceedings affidavit. So these things, then objections will be there. You have to clear it through your responses. Next.
What are some of the practical loopholes that the presenter has observed in the registration process of various IPs?
The practical loopholes being the attitude of the hearing officers in the registry's office and the examiners. I think no doubt I am not undermining their knowledge also, but there are judgments which we plead that, sir, listen, this trademark is actually registrable, and this is the judgment. Backing is registration. They'll ignore the judgment. Quote unquote, some people even say go file an appeal. They know that appeal will go for 10 years. By that time, I'll be enjoying retirement in Mussoorie. I'm not liable. So they don't care about the judgments. So they said, plead your judgments in the High Court. So once I reminded a hearing officer under Article 141, this registry is bound by the jurisdiction of the the orders of the Supreme Court. Then I got a favorable order. So these are practical problems which we face. So the examiners who are in the registries are not very adept to the law, and senior examiners are comparatively higher in knowledge, and like they have more experience and they are adept to the law. But again, I told you it's a case to case basis. I feel that the mark is registrable. Someone else might not feel, and that someone else might be the examiner. Howsoever you plead, it will not get registered. Then you have to take do other tactics. For example, somebody says, okay, Casablanca mark is not registered because there is a Casablanca already in the register. I said, no, 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 my Casablanca is different because it's a device mark. It doesn't matter, it's a word mark which is registered. Then I file a rectification application saying that, okay, Casablanca as a word mark, they have not used it in India. So my mark need to get registered. I have a proper right in India, and trademark law being a federal right jurisdiction, you have to register my mark. So once the rectification process, if we succeed, then we refile the application. Then my mark then again, if the registrar says, okay, no, this mark has been registered, like no, this mark has been removed because we filed rectification application to show that we have the right. They don't have the right because they haven't used it in India, even though they have registered the mark and kept it in the registry. Or you may file an appeal in the Intellectual Property Appellate Board or in the registry's office. Sorry, appeal against registry order in the Intellectual Property Appellate Board. And if you want to file a rectification application, it needs to be filed either in the registry or in the Intellectual Property Appellate Board. I hope I answered your question. Next.
How do you think PS5 was registered when PlayStation is a well known trademark?
So it's a very common issue in the trademark registry industry. People tend to file for application for registration of trademark, which is quite famous in the world. So before the corporation actually register the trademark, some random guy will go and register trademark, because as I said, the examiner are not well versed with the law as well as the facts which are going on. They are like machines in the registry. They say, okay, PS5, अच्छा 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 देखते हैं, is it similar to any other mark? PS5, no, it's not similar to any other mark. There is no other mark registered in the registry's website. Okay, you have the right to get it registered. They don't check whether they actually has the right. If the mark is not there in the registry's website, if Sony Corporation has failed to register the mark PS5 first, then anybody can go and get it registered first. Subsequently, in the Delhi High Court, they will show no. This is trademark trafficking. He has no plausible rights in the mark. We have been marketing it. We have been doing all the developments in the past 3 years. We'll show this is a trademark trafficking. Recently, there is an example. Fair and Lovely got changed to Glow and Lovely. Somebody, random guy, filed a Glow and Lovely application. Because his mark, if he gets registered, then he'll sell that mark to the company in a view. He'll earn some money. These are useless people. They do this. Very common in the industry. A lot of people do this to earn money. Because if you are not the registered owner of the mark, you'll rather buy the trademark and launch the product immediately, rather than going into a protracted litigation. Next question.
What database do you use to assess risk other than the government database?
Oh, that's a very private question. We use there are companies who are being hired by the law firms and the companies to analyze which all marks are very similar. Once you're in the industry, you will get to know. People will approach you automatically. Thank you.
The next question would be, is trademark applicable for profitable institution, or is it even applicable for non-profitable institutions too? If it is not applicable for non-profitable institutions, then how can the name of an educational institution can be considered as a trademark?
So you have the answer into your question itself. Any institution can register a trademark. I have a trademark registered in my name. I'm using it for certain services. Any person can register a trademark. Doesn't matter whether profit or not profit. The point being, whether your goods, the services which you are offering, whether commercial or not commercial in nature, is it different from that of others? Are you distinctive enough? The point is being distinctive, different, not similar. There is no question about being profit when you are applying an application. Next question.
Isn't registration of trademark reducing the importance of registration of copyright?
No, that's the wrong question. Registration of trademark is very necessary, because unless you have a trademark registered, you cannot file an infringement suit. Under section 29 of the Trademarks Act, you need to have your trademark registered only to claim an action of infringement of trademark. It's a legislative right as compared to copyright, which is an inherent right. Whether your whether your work is registered or not registered, you have a claim under the action of infringement provision in the Copyright Act. So it doesn't matter whether your work is registered or not registered. I have clicked a photograph. If somebody copied the photograph and used it for his commercial purposes, I have an actionable claim against him. I'll say he has infringed my copyright. But to say that my trademark has been infringed, I need to have my mark registered first, or else I have to go through passing of action. That is a common law action. I'll say, no, I've been using my landmark since 1999. I have not registered it. Somebody else has registered it in respect of similar goods and services. He can't, because I have a common law action. I have he's passing off his goods under my trademark. So I have a common law action. I hope this answers your question. Next.
Can I protect my trademark by registering it before I could start using it?
Absolutely. That's why you file it as a proposed to be used mark. If you have not used it, you file it as a proposed to be used mark. It's up to you. You want to use it, it gives better chances of registration. If you don't want to use it and go ahead with filing it, then go ahead. Nobody's stopping you. Next.
Does GI tag belonging to a particular place favor an individual to register a trademark? For
No,
example,
GI. Sorry. Yes.
Mysore saris, Bikaner bhujia, etc., or anyone can use it.
See, uh, can you please enable the participant screen sharing, host?
Yeah, done. Sorry.
Yes, can you please repeat the question? Sorry, I missed it.
Yes. Does GI tag belonging to a particular place favors an individual to register a trademark? For example, Mysore sari, Bikaner bhujia, etc., or anyone can use it.
So I'll give you an example. Champagne is a type of sparkling wine. You can sell your wine as a sparkling wine, but cannot use the word champagne. Why? Because that's a GI. Only available to the farmers and traders of the particular region of France who is producing that particular sparkling wine. As it's being produced in that particular region, they are going to get the benefit of naming it champagne and not as a regular sparkling wine. It's the regular sparkling wine. Name it champagne, it's 5,000 or 10,000 rupees more. Now, any traders or farmers want to register a trademark using the name champagne has a right to do it because he falls within that particular jurisdiction. But before that, he needs to have a distinctive mark. If he wants to register champagne in his own name, he needs, for example, Lorraine champagne. Champagne being a common word, is a GI word. The registry will only look into the fact whether that person belongs to that particular region or not. Let's come back to India, for example, Darjeeling tea. If somebody wants to apply for Darjeeling tea, that person need to have a license in that particular region of Darjeeling, in particular hills of Darjeeling issued by the Darjeeling authority, whatever it is. CTC Darjeeling tea, get it registered. CTC being the distinctive mark, Darjeeling tea being the mark of the GI because they are right now registered there. They can have it, that's not a problem. But the provided you have to stay in that place and you need to have a separate mark which is before that mark, before that GI, because GI you cannot register as a trademark. You cannot register as a trademark if you put a word before that GI. And then the registry has these differences of opinions whether you can register it or not. And if they refuse it, then you have the claim sustainable in High Court or whatever. Next question, please.
The next question would be, can a trademark be asked for something which is not in existence at the moment and would not be in existence for the next 10 to 12 years, like PS15X?
Once you register a trademark under the trademark law, you have to use it within 5 years of registration. If you have registered the trademark as proposed to be used, you have to use it within 5 years of registration, or else your trademark is liable to be rectified or removed from the register. If you have claimed registration 1999 in your trademark application in 2011 and then you subsequently get the registration in 2012 and you have stopped using it for the next 5 years, your trademark is liable to be removed. You adopt a word PS5, you get it registered, you have to show that you are using it for the next 5 years or momentarily in like in 2 years or 3 years, to show that okay, you are using it. PS15, we are talking about it, you have to show some use or else your mark is liable to registration. India has this loophole in this law that we don't have to subsequently show use after registering a trademark. But US, once you apply the mark for registration, within 5 years you have to show use that you are using the mark with documents. If it's not shown, the registry itself will remove the mark. US Patent and Trademark Office in this situation, not registry, they will itself remove the mark. No third party claim needs to be arising. This is being done to reduce the litigation. India doesn't follow that. That's why it's of course you need to use your mark. You cannot make sit it idly. If it's sitting idly there, it's liable to rectification. It's liable to removal. Next question, please.
So this being the last question, do you have any guidance or tips about how should a fresher or a student should go about the IPR practice or litigation?
See, before answering that question, I'll just give you a basic idea what I do in my firm. You guys can check my LinkedIn profile. I do strategizing the trademark which you need to apply, application process, the entire application process, the opposition process, the rectification process, the litigation, the transactional work which is need to be done. There are a lot of different kind of transaction which is required for trademark practice. It's not that easy. 40%, 60% of well-known well-known brand has 40%, 60% value in the entire company. For example, if you take out Coca-Cola from the bottle, nobody will buy it. So if somebody is buying Coca-Cola, the Coca-Cola trademark itself has 60% of value. So those kind of things are carried out in transaction, those kind of work, purchase and all. There are due diligence which I do for trademark, copyrights and intellectual property rights as a whole, and information technology also is very cognitive of right. Another practice which is very cognitive of a trademark practice is media. I don't do it properly, but yeah, sometimes yes. So now you have so many options. You either want to become a litigation lawyer, or you want to become a prosecution lawyer who only does the registry work, or you want to become a transactional lawyer, or you want to do all of them. I do all of them. How do you develop the acumen to do all of them? Read the law. Whatever I'm telling you, it's in the back of my head since the day I graduated. My law is clear. What is a trademark infringement? What can be registered as a trademark? That thing I know. Copyright, what is a copyright? What kind of rights are there? What is moral right? What is economic right? Those things I know. The law is very important. After the law, of course, the internships are very important. You have to do internships in trademark specialized firms specializing in IPR practice, whichever IP practice you want to do. I don't do patent law because I don't have a science background. The person after me will explain. Now, do the IP practice, write papers if you want to, go for conferences. You need to have a very good interest in that particular area of law. Before third year, I had no interest in IP law. It was an accident, but I love it now. Read the judgment. Once you read the judgments of the IP law, you will love it. If you really want to take an active interest in IP law, read the judgments. Judgments clear out most of your problems. It will make you interested in IP law. There are so many facets to intellectual property. Even though it's a very specialized branch of law, it is very, 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 very beautiful. This is because I love it. You need to love it. Only you can make a career out of it. If you love it, you will know how to proceed further. Be very thorough in your law. Be then only you will be prepared well for your interviews, because they will ask you about the law, not about the practice. For the practice, you go for the internships in your specialized trademark or intellectual property teams in different law firms, and then of course you apply for the job. Can I proceed with my lecture?
Yeah,
So we
yeah.
have one last question.
Okay.
In quotes, I do not own the copyrights to this video. What's the scope of the disclaimer? Because most of the content makers are making money from the content of others, especially since the pandemic. People have found ways to infringe easily online.
See, that's a scope for a different lecture altogether. If your professor asks me, it's a very wide answer. I cannot answer it in within 1 or 2 minutes. This is a very copyright. This question needs to be addressed from a different point of view. What are the different rights, adaptation rights? So it's a proper 2 hours long lecture. We need to analyze the law from judgment perspective. So sorry, I can't won't be able to answer this question right now. Can I proceed?
Yes, sir.
Sorry, I think we have. Yes. So in your on your screen, you can see these are trademark journal. This is the type of trademark journal. This is a class 13 journal. As you can see, this is a class 13. This is the date of application. This is the journal 19. Sorry, this is the date of journal date. So 30/11 being the date of journal. So you have a time till 30 December, January, February, March, 30 March, till you have 30 March time to file an opposition against this particular mark. This is the mark. If you go to the registry's website, you can take out proper details about the mark, other details about the mark. This is typically a journal. These are the journal. There are a lot of trademarks filed in journals. I mean, gets advertised in journals. Different from different classes. I think class 13 got over, so it's class 14 now. So this is a journal I wanted to show you. Okay, let's show you some related links. This is the form. There are different forms. These are the applications. See, if you go to others, these are the trademark application class you have to fill. For example, 42. Submit. So different classes are there. Uh, so this is the name and address of the attorney. This is the mark if you want to do a trademark. These are the goods and services where you need to attach the goods and services. This is whether it's proposed to be used. If it's not proposed to be used, then whether the mark has been used. Mark has been used since whichever date. Okay, then you attach the documents. Authorization document is there. If it's a startup, then you have to apply for a certificate of startup. You have to show that because startup has a 4,500 rupee application fees. This is a user affidavit. Uh, if it's a logo mark, then you have to device mark, shape of goods mark, sound mark, 3-dimensional marks, and word mark are there. Color mark is also there. It's better to apply for a device mark or a word mark. This is the mostly preferred option. If it's a device mark, you have to name the device mark and you have to give an exam description of the device mark. If the device mark is very complicated, it has a lot of designs, you upload the image. The image needs to be filed in a particular format that you'll understand once you do that. So these are the other forms are there. This is a TMP form. There's a post registration forms are there. Add or alter trademarks, add or alter address and registered proprietary user. There's so many forms are there. Subsequent applications. Okay. Subsequent proprietor by way of assignment or transfer of trademark. Okay. Then it takes an entire day to explain to you all the forms. So then there will be there's a drafted application page. There you drafted application, then you sign the application through digital signature, then you make a payment in the payment gateway. When the application is signed, it will show in this area. Okay, and you want to do other filings, for example response to examination report. These are without payment options. Reply to copyright NOC matter, miscellaneous, that is for TMC, response to examination report, evidence in support of opposition. uh, these are all the things. Once you go to the firm, they will explain it to you. So I'm just signing it out because I have only 10 minutes remaining for me to summarize the entire infringement of trademark and copyright. So let's just go to the infringement part of the trademark and copyrights. Most important and very interesting part of the session. That is, where does a suit for infringement of a trademark and a copyright or a passing of action lies? Jurisdiction of the court is very important, where you need to file a suit, because only a court of original civil jurisdiction can entertain the suit for infringement of trademark or copyright. Now, if you go to section 62 or 134 of the 62 of the Copyright Act or section 134 of the Trademarks Act, it will mandate that a court which has the original local jurisdiction, a district court which has the original local jurisdiction, is the proper place to file the suit. So now we know that we get established, this fact is established that district court is the proper place to file the suit as per the copyright or the trademarks. Now, people then ask that why don't we go for a section 20 CPC jurisdiction if we want to file a suit for infringement of person. Now, Copyright Act and Trademarks Act being very specialized acts, therefore they have provided the jurisdiction in the act itself. So the jurisdiction which has been provided in the act itself, as per the judgment of the Supreme Court and the High Courts, are an addition to the jurisdiction which has been provided in the section 20 of CPC. People prefer to go under section 62 and 134 for certain reasons. Why? I'll tell you. Section 20 of CPC says that you can institute a suit where the defendant resides, at a place where the defendant carries out its business or works for gain, or at a place where at least a portion, a part of the cause of action arises. That is section 20 CPC for you. That is the jurisdiction of the court in which you can try the suit. Section 62 and section 134 of the Copyright and Trademarks Act respectively says exactly opposite. It says you can file a suit while the plaintiff resides or ordinarily carries its business or as a principal seat of business. Why it is different? Here we are talking about defendant in CPC, and here we are talking about plaintiff in copyright and trademarks. Why? Why not defendant? And that's why there is a defendant jurisdiction. That's why these are specialized acts. The working committee, the joint working committee of the parliament was of the view that when a copyright or a trademark is infringed, it is simultaneously infringed in a lot of places. For example, my song has been copied by Mr. A, Mr. X, Mr. Y. Mr. A is residing in Delhi, Mr. X is residing in Chennai, Mr. Y is residing in Kolkata. I stay in Mumbai. What do I do? And there are so many other people who has infringed my copyright in that song. What do? I can't go to each and every place and do a separate suit. It takes a lot of effort in doing that, physical and monetary, everything. So I have an option under the section 62 and 134, section 62 of Copyright Act, to file the suit at a place where I reside, or I carry my business, or I have a principal seat of business. These are the people who have infringed my copyright in the work are liable to come here in Bombay and say, no, I have not infringed. Whatever they do, whatever the submissions are, but I have a right to institute the suit in the place where I stay, and not at the place where the defendant resides, that is being Delhi, Calcutta, or Chennai. So the nature of the rights of the trademark and copyright is so inherent, and common law is a right occurring in common law, that it's very difficult for the person who is going to institute the suit at such a place where the defendant resides, because there can be simultaneous infringements of trademark. Puma and Nike can be infringed by so many people because of the mark is so well known. The song gets infringed by so many people because the song is so well known. Badshah infringed someone's song. The guy took out an action in Calcutta High Court. Badshah came and gave some money, said we acknowledge his effort, and he gave us 5-second view of that guy in his song. But he came down to Calcutta. So section 62 and 134 of the Trademarks and Copyright and Trademarks Act has this provision that where the plaintiff resides, you can institute a suit, or ordinarily carries his business, or the principal seats of business. Now, you have to read this in addition with the original civil jurisdiction of the district court. If you read section 62 or 134, you will understand that the court where the case needs to be instituted needs to be a district court, and district court has original civil jurisdiction. But four high courts, not four, five high courts of India has original civil jurisdiction. High Court of Bombay, High Court of Chennai, High Court of Kolkata, High Court of Calcutta, and Delhi High Court, and Himachal Pradesh High Court has original jurisdiction. So you can directly file in the High Court. You don't have to go through the district court. You first file the district court and then you file in the High Court. No, if the High Court has the original jurisdiction in that particular area where the plaintiff resides, then you can file the case in that particular High Court. These are the high courts where you can file. These have the original jurisdiction. That doesn't matter that Calcutta High Court has original jurisdiction over the entire state. No, Calcutta High Court has original jurisdiction over a particular area as notified by the rules. You have to read the rules of the High Court, particular High Court. Bombay High Court has its jurisdiction over Mumbai metropolitan area. So a suit need to be tried in the Pune District Court for infringement of copyright and trademark need to be tried in Pune Court and cannot be tried in High Court of Mumbai. So these are the jurisdictional issues you have to understand before filing an action of trademark copyright. Now, after the Commercial Court has come in India, the Commercial Court Act has come in India, only a commercial division of the High Court or a commercial court or commercial district court can hear the suit for the intellectual property rights violations. Therefore, a suit for intellectual property right violation, that is being the trademark or a copyright or a patent right, can be only heard by the commercial court. Now, where it also says where the commercial court, where the High Court has the original jurisdiction, you don't have to establish a separate commercial court of district or a district court. You don't have to give a district court a power to entertain commercial suit for intellectual property law. The High Court can itself try the suits because it has the original civil jurisdiction. So the High Court will be given a separate commercial division for the commercial suit. So when we file a infringement suit in Bombay, we directly file in Bombay High Court, and there is no pecuniary jurisdiction for this particular kind of suit. There is no minimum claim amount where that if you have 1 lakh, you cannot file in Bombay High Court for infringement of trademark and copyright. That is in Bombay High Court. I can only talk about Bombay High Court because I practice there. Bombay High Court doesn't have any pecuniary jurisdiction when it comes to trademark suit. Any kind of claim will be entertained in Bombay High Court if there is an infringement of trademark or copyright, and it happened within the jurisdiction of within the ordinary civil jurisdiction of Bombay High Court. Now, while filing a suit for infringement of trademark and copyright and passing of action, we also file a interim application. In Bombay High Court, we call it interim application. In other high courts, we call it for application for interim injunction. In district court, we call it interlocutory injunction and interim injunction. So that application needs to be filed. Why? Because during the pendency of the suit will go on for 10 years, 5 years, 10 years, whatever. During the pendency of the suit, the plaintiff needs some immediate relief. If a patent has been infringed, then the person who has infringed the patent, whether he has infringed the patent or not, the court will take n number of years to actually decide on that case. But during the pendency of the trial or during the pendency of the suit, my rights are getting affected. My patent rights are getting affected, and therefore I need an immediate option, immediate action against that particular person. So I need an interim application. That interim application is filed under the Order 39 of CPC. Under Order 39 of CPC, the High Court appoints receiver of the court to actually go to the property where the particular infringing material is there, the trademark and copyright, and seize the property, seal the thing. I have gone to different parts of the country with the Bombay High Court order, going to I've gone there, entered the place and seized the goods. I think I'm running short of time. I think that being said, we can go on for another 1 hour to explain how the suit for infringement takes place, what the process and everything. But I'll not take much time of sir who is immediately next to me for this lecture. So thank you guys. Thanks a lot. I'll rest my.
Thank you for an excellent presentation, sir. It was very informative, and your guidance has served us well. So, thank you very much.
Thank you. Thank you.
Next, we are honored to have Mr. Rajiv K.R. Chowdhury, a renowned Supreme Court advocate who has years of experience in IP litigation, not only in India, but also in various jurisdictions like US and Europe. It here too, he has filed and obtained around 3,000 trademarks and copyrights over the years. He is also the founder member of Fair Standards Alliance, an industry body for promoting fair licensing of standard patents. He specializes and mostly focuses on SCP licensing related litigation, electrical patent procurement, IP asset management, licensing, and corporate advisory. It is an honor and pleasure to have you, sir. Finally, if any of y'all have questions during the presentation, please type them in the chat box. I'll present it at the end of the presentation.
Please hold on. I think he has a problem in joining. Rajiv sir is facing a little bit of an issue with the internet. So what we'll do is we'll take a 10-minute break. Don't leave the session, but maybe take a break.
Hello?
Yes, sir, we can hear you.
Great. Great. Perfect. So, should I start?
Yes, please. Yeah, please go on.
Uh, Thank you. Thank you for the comments, regarding me. Greatly honored to be here. And I was hearing Neil. I mean, really a learning experience for me as well. I might add that. And my pleasure to be with you all. So let me just start from the very basics that why exactly, patents? Uh, why not trademarks or copyrights or some other form of protection? So like trademarks and copyrights, patents are also exclusionary rights. They have their origin in tort laws. And as I said, I'll repeat it. They are exclusionary rights granted by the sovereign. Like trademarks, like copyrights, patents are also granted by the sovereign. In our case, by India. In the case of US. In Europe, even though they have a single system called the European uh, Patent, Commission and the articles of the EPC, uh, you know, they grant patents country by country, even though prosecution is going to be centralized. Once you go to assert patents, same way like in India, you can assert your patent anywhere in the original high courts where the patent was registered or filed, and it's your choice basically. So let's say Philips, for example, even though it is present in India, but it chooses to bring its patent cases in the Delhi High Court. Uh, For others, it could be the Madras High Court, the Bombay High Court, or the Kolkata High Courts. Now, why these four high courts, or rather say, I should say five high courts? Uh, it is the high courts having original jurisdiction. And originally only, Delhi, Bombay, Madras and Calcutta high courts have had the jurisdiction. And later on, we had Shimla, the British, system still continuing. So only these five high courts have original jurisdiction, and it is only after the Commercial Courts Act that cases can be filed before any high court having the commercial jurisdiction to hear that particular matter. So it could be Bangalore as well. The Karnataka High Court having its seat in Bangalore, or any other high court, Hyderabad maybe, whichever way it is. So the way I thought of how should I go about this presentation, and I understood that I'll be the second speaker of the day, and I understand that you all are there since the morning 9:30 a.m. So I'll try to keep it brief. I'll try to make it interactive, and I see that there is some way where you guys can raise your hands. Uh, you know, so my view is to ask you to raise your hands in the event that I ask a question. So if I see the number of hands, I'll try to calculate how many hands are there, and I'll tell that okay, this is the way that all participants are responding to this particular issue, and I'll tell it that what is the view of other participants. So very basically, I'll start with the criteria for patents. And one thing that I must clarify very, very early on is that there are some basic criteria that are similar across the globe. It is not just that, these criteria are there in India. You have very similar criteria, let's say in the US or in the Europe. It is only in the way where you, let's say, draft an application. In the implementation, the thing differs. So, and this comes from the international treaties. There are multiple treaties, across the world. One is, of course, the Patent Cooperation Treaty, and the other is even older. This is almost now 150 years old, the Paris Convention Treaty. Now, under this, countries are supposed to protect, their citizens' intellectual property, whatever is coming out from their head. And like all other forms of intellectual property, it is intellectual because it is coming out of your the head, the intellect of the person or the inventor, or the, let's say, the trademark filer. There is nothing tangible. This is an intangible product, and that is how it is protected. So trademark has its own, set of rules. Patents has its own set of rules. Similarly, copyrights. Uh, Another form of patents is called as design registrations. We call it design registrations in India, and elsewhere it might be design patents or design registrations. These are for the form of, let's say, the article. Let me just show you one, so you guys can see this. This is a pencil sharpener, and this is a made in the way of a a ATM kind of a machine. And what is protected is the shape, not the color, the shape, the views that you are getting. It is a normal sharpener, but nobody else can go ahead and get registration for this. Another one is, I mean, this is a case for design. This is all screwdrivers. This is uh, again a design registration. This is not a normal patent. Now, what do I mean by a normal patent? Um, this device, this is a normal mobile phone. Uh, of course, there are standard essential patents, but let me just explain what is there. See, the way that this device works is according to certain technical parameters, how the thing works. And this is what is patent protected. It could be anything. It could be a very, very simple shape. Let's say, you know, uh, the functionality, apart from the functionality, how it functions, not the end result, but the way you reach that end functionality, this is what is patent protected. And once again, I'll come back to the very basic. Globally, they are the same. These are three things. The application should be either industrially applicable or useful. Industrial application is a term used in India, in Europe. In the US, they use the term useful. And in Japan also, they use the term industrially applicable. So, and the use of this term is, I guess, it should be useful for a particular purpose. It should not be a theoretical machine. Let's say a time machine or something to cure cancer. No, that won't work. It should be useful for some particular purpose. And then it should be novel, or it should not have been anticipated. Again, these are interchangeable terms. The usage is similar across US, India, Europe, Japan. And the third part is, it should not be obvious. And to whom it should not be obvious? It should not be obvious to somebody who is skilled in the art. Considering what? Considering what is state of the art or general knowledge in the field. Now, I might have told you this definition of obviousness, but if you look at section 21JA and 21J of the Act, you will see this definition. In the US, you will see section 103 of their 35 USC 103. Under the EPC, you will see Article 56, Article 54. Similarly, in Japan, section 2, section 3 of their Patent Act. Uh, very similar across their functionality, across their structure, across the way they are implemented. And how they are implemented is what each jurisdiction has to add on. And so let me just come back to how to create a patent application. uh, if you, let's say, let me just start sharing my screen now. Okay. So very briefly, this act may be called as a patent act. It extends to the whole of India, and that's why it's granted by the sovereign. Indian patent will be granted only in India. Similarly, US patent will be granted and applicable only in the US. Definitions. Let's come to. So I talked about industrial application. Section 2(1) AC, capable of industrial applications in relation to an invention, means that the invention is capable of being made or used in an industry. Then uh, let me come to section J. Invention means a new product or a process involving an inventive step and capable of industrial application. Second is JA, inventive step. So this is for obviousness, means a feature of an invention that involves a technical advance as compared to existing knowledge or having an economic significance or both, and that makes the invention not obvious to a person skilled in the art. Now, if you let's say look at you ask, okay, I understand all that, but what does capable of industrial application mean? Uh, so let me just come down to some case law as to this. Uh, uh, so there is some, let's say, historical context. So this is a 2002 case where this is Demi Napko AG versus the controller of patents from the Kolkata High Court. This is where this dates to biotechnology. Now, in biotechnology patent applications, uh, there is a sequence of human genomes, so which is different sequences of A, T, C, and G, just put on over and over and again. So small forms of this build proteins, and then larger proteins build the entire gene sequence. So this particular, the patent office said that, look, we can't grant a particular this biotechnology sequence gene sequence application a patent, for which this was the case that started off the entire thing. The Kolkata High Court said that, look, you grant patents to you know everything except for things that are listed out in section 3. uh, let's say, for example, the court said that patents could be granted for non-living substances that generated by chemical or biological means, which means that you use some bioconversion means to convert, let's say, the basic A, T, C, and G, and you express it in a very particular format, and that's what is the product of the human intellect. So the court agreed that yes, it is useful. It has industrial application. The test that was applied was for capable of industrial application. The patent office was going on the basis that this has got no basis. There is no industrial application of this particular thing. There is another case law from the IPAB. This is University of Miami versus a controller of patents. Once again, the patent office said this is not useful, but they did not give out any reasons. So the IPAB said that you have to give reasons, and for your dismissing of any particular application, it can't be that you don't give a reason. You have to give reasons, and that's how they sent it back. And of course, now it is being prosecuted. The examiner must give proper guidelines as to why, proper reasons as to why it is not. Similar is the position, as I said, in Europe. They also use the term, industrially applicable. Uh, this is on the basis of Article 54(2). Uh, Let me just pull out another, uh, you know, thing from the guideline. Uh, so this is there is a section of guidelines from the patent office that talk about what is industrially applicable, uh, and they give out examples. So they say that synthetic analog of a steroid, This steroid is, it's a drug, it possesses certain medicinal properties. However, the compounds of the invention as asserted are subjects of investigation, being the analog of compounds known for medicinal properties. And so the patent office says that these are not patentable as they lack any and specific utility. You just can't say, oh, this is a steroid and I'm going to use it as a steroid. The patent office will straight away come back with the rejection that it is not necessarily applicable or you have not provided a use for it. Um, so that's about industrial application. And now coming to the second aspect of it, this is section 21J. Now, invention means a new product or process. So just understand from there, what is new? This term new product or process is something that is, to be understood as something absolutely different. Something new means actually new. It should not be there in existence anywhere in the world. And the patent office or the examiner can look at existing things, existing patents, even existing movies, existing let's say podcasts, to say that look, this was disclosed in some conference or some discussion where people must have written about it or talked about it, so as to be able to say that this is not new. So what, so suppose I say that look, I have created this on this platform, Zoom, uh, a voting button, right, where you can say yes or no, and I say this is a new application that I've created for Zoom. Well, the patent office will say, okay, fine, it is useful, but it is not new. Why is it not new? Because it is already known. How is it known? There are multiple, let's say, in your WhatsApp chat or in your any of your online exams, you can select answers, put in your answer choice A, B, C, D, and hence, this thing is already known. What are you talking about? This is not new. So that's why we can't give it a patent. And they are very particular to say that look, this is already known in one single field. So whatever in when you say that, when the patent office says this is not novel, they say that whatever you have disclosed is disclosed by one single reference. They can't combine. When they say the invention is not novel or it is anticipated, it is not new, it means that they are saying that look, we have taken a look at this particular document or this particular video or this particular podcast or this particular patent or this conference paper. It discloses each and everything that you are talking about. Nothing is new in what your in your invention. That's why we can't give you a patent. And similar is the case in under the EPC. I'll be giving you some case law on it later. Similar is the case in the US. Uh, in the US, they use the term uh, novelty. Under the EPC, they use not anticipated, but same thing. And the concept is the same. One single document should disclose each and everything. Means that document or patent or whatever it is destroys this newness. So that's why you can't get a patent. The second part is inventive step. Now this inventive step, uh, is something that is called as, under quotes, very similar to obviousness. So if something that has an inventive step, you know, is able to, somebody that is uh, both has industrial application, is not barred under the laws, has novelty, and is not, has an inventive step, is granted a patent. So means a feature of an inventive step means a feature of an invention that involves a technical advance as compared to the existing knowledge or having economic significance or both. And that makes the invention not obvious to a person skilled in the art. Uh, so all this, you see this technical advance compared to the existing knowledge or having economic significance, this part, and makes the obvious invention of not obvious to a person skilled in the art. Even this is some term that you must make note of. Uh, See, these are different parts of the definition. And how do we see what is technical advance, what is, compared to existing knowledge, economic, what is economic significance, and not obvious to who? To a person skilled in the art. Obviously, let's say if the invention is about, let's say, a mobile phone, obviously, a pharmacist is not a person skilled in the art. It has to be a engineer. It can't be, that pharmacist is the person skilled in the art, or a patent attorney is not skilled in the art. It has to be an engineer or somebody who does that regularly. Um, but this is very important to understand these definitions and perspective. It is very important for you folks, because you folks, I'm assuming you don't have a science background, so you can definitely litigate, about whether the patent is valid, whether it is, properly granted, what all is there under that, and that's what you need to present in court. And as in any other case, you would look at the very, very basic issues. So let's say if I look at, section 13, 12 and 13. So 13 is specifically, it says that, search for anticipation by previous publication and by prior claim. And then it goes on. There is another set of sections, let's say from 29 to 34. Look at that: anticipation by previous publication, anticipation by previous communication, uh, public display. All these are exceptions to what is anticipation and what is not. So you must know your basics to be able to say that, look, this is how this patent is valid, or you must be able to defend your client's patent, saying that, look, this is improper objection, and this won't be sustainable in a court of law, or this patent be sustained or not. And then our act has certain peculiarities. For example, you have this opposition to the patent. One is obviously pre-grant opposition, another is post-grant opposition, and then we have section 64, revocation of patents. And if you see in detail section 25.1, 25.2, section 64, this is all what they are saying. The grounds that are there basically are a variation on industrially applicable, novelty, and third is uh, having an inventive step. So it is very important for you to understand these three basics. Let me just now, pull up a patent specification and, tell you how exactly it is going about. So once again, I'll go to IP India. Okay, so this is the patent application search. There are a lot of fields. For example, let me just go about these fields. Uh, Application date and all. This is not important for you, but what is important is the title, abstract. Field also is somewhat not important. The other fields, this search field, sort of important for you. Applicant country, somewhat important if it is some client has filed an application under the PCT or under the Paris Convention, they can file in India. So let's look for an application that is in the title, there are some particular words that are there. Um so let's say I just looked at two words, aided and digital, and I want to look at computer image processing. So let's say, so this looks interesting, the first one, consumption and simulation of digital modems. And so we go to application status, and let's see the documents that are there. So can you see this? Anybody can just type in the chat box. Great. So this is the form and format. Form 2 is what you are looking at. And so these are the applicants. So these are the people who are there. And consummation and simulation of digital modems. Now there are some headings that are there. So number 2 is preamble to the description, consummation and simulation of digital modems, description, field, background, summary of invention, and of course claims. This is not that detailed, but one thing that I like this. This is short one. One thing that is there is it should be person very clear to someone that what exactly is this guy talking about. So you see this title, consummation and simulation of digital modems. So the moment I see these words, I'm like, okay, I know this is talking about, of course, this is talking about modems. But what this guy is saying is, I will simulate a modem in a computer. I will create a software that mimics the behavior of a modem. And he says, this is my description. Digital modems are this is what is known. And then the proposed, so here you go, the proposed modulators make an attempt not to use of any so-and-so. This is a key feature. In light of the acknowledgement method, this examination proposed new computations for, this is something that is there in this particular invention. And now come to the claims. This is, I guess, there is no agent over here. So these are the claims that they have written. You can't have claims that are relatively fast or relatively area efficient. There is one thing that I used over here. Anybody should this claim, no? Once you read this claim, it should be clear as to what exactly is going about in this particular area. What is this guy talking about, or what are the inventions talking about? Once you see, let's say, a process of this particular process, this will be, not be granted. They will have to amend the claims. They will, of course, now it is published, so they can't even add more content to it, but they will have to change the language of the claims as well. So these claims are based on section 10 and of the section 10 of the act, that says that it must be detailed and sufficient to a person skilled in the art. You must provide what your invention is doing. And over here, the Indian law is similar to the US law. The Indian law says that the invention must disclose the best mode of implementing the invention, and Similar is the case with the US law. But one thing that I want you to note is these headings: summary of the invention, claims, description, background, field, etc. Um, from three, they wouldn't have applied, but that's about it. Let me just look at another. This is another way I like to see patents. So let's use the same words: digital. Okay, so this is a granted patent. The way I can tell is, you see this number, US 51668. This is, I know this is a granted patent. Why? Because this is the series in which it is granted, and this is actually expired. Okay, so now look at the headings: method and apparatus of so and so, abstract, same as India. Um, so this is the abstract. We also had a separate abstract. That was the document that you saw. The one you saw didn't have any drawings. This guy has drawings. Um, okay, so it starts with the title, and then every line is numbered. You see this 5, 10, 15. This is how, the US does it. Our patent office requires us to have not a dual column but a single column structure, the way you saw in our application, and each line has to be numbered 5. So you'll see this 5, 10, 15, 20 on the left side, single column arrangement. Then you see the summary. You saw the summary in our patent application as well. Even though, the examiners didn't, I'm sorry, the inventors did not use a patent agent, they drafted and filed the patent application themselves. And now you see this detailed description. We saw a description in our one, the Indian one. And each and every, see, if you read, I'll just come to the claims. So this guy is explaining what the invention is. So let's read the claim one. It should be clear to you that what exactly is going about. So they say this is what? This is a method of surveying for a compilation of detailed three-dimensional topographic area, which consists of coordinates of a plurality of detail points on terrain and corresponding points on terrain and corresponding topographic point codes, comprising the steps of. So first they are saying that we will scan photographically. Here the drawings that you would have seen must have helped you. You could have seen that they had a car that took photographs, and they are trying to create a digital map. From there, they will point out that this is what each particular object is. Panoramic recording of the terrain without determining a position of the coordinates. Set panoramic recording subtending 360 degrees, which means all around. They're taking a round picture and then sticking all the bits together. And this is a quite a detailed claim, and you get what this guy is saying. So this is what this invention is all about. This is what the protection has been granted to him. So the best example that I can think of this particular claim being used is, you see Google Maps. This is what it is, and I'm sure this would have been assigned to, must have been an important enough patent. So let's just go to the okay. So this is a quite an important one. So this is nice enough date to basically make sure that this particular thing is used. And so this is what a patent is. You've seen the granted patent. Let us just try to see the the prosecution history of this particular patent. We saw the granted claims. It will be interesting to see this patent's prosecution history as to what happened in the patent office. This application was not filed in the same way what you are seeing right now. It was filed in a similar manner like the way we saw in India. It was examined by the US Patent Office. You see this examiner's details, and you see this these two references. You know, this Ratcliffe Jr., this one. So these are the references that have been cited. I'll try to pull up the file for this one so that you can see what is going on. Or would you like to see a one in India? I mean, just let me know. Anybody can type it in the chat box. Okay, let me just pull up something from India. Great, somebody has said India. Okay, so this is granted patent. Um, that I remember the title, um, and this one, this is coming from the PCT national phase application, which means that it was filed in some other country first, and then it entered national phase in India. That's what you see the details. Date of filing is 2001. Applicant is Rickson. And title is Linear Predictive Analysis by Synthesis and Coding Method and Encoder. So this is a bit important for you. Priority date is 16/9/1998. So priority date is important date for you guys to know, because in litigation what happens is any particular document or video or podcast or conference paper that the examiner must look at for both cases to determine novelty and to determine obviousness should be before this particular date of priority date. So let's say you disclose a particular, you file your patent application on let's say 16/9/1998. So the examiner can't cite anything, that is after this date. This is a hard date. The examiner can cite only, things prior to this date. So let's look at the documents. And as I said, I just want you to have a look at form 2. Um, Title, important. You see this following specification particularly describes. This has to be there for all Indian, you know, complete specification. So this is a complete specification. This is not a provisional. So had it been a provisional, it would have been said, would have said this following specification describes. The present invention relates to a linear predictive analysis by synthesis, so and so. The background summary, you see the headings, and so they are taking this PCT, WO so and so, PCT so and so, figure 3, 1, 2, 3, detailed description. There are certain equations. And let's see, small claim, linear predictive analysis by synthesis, coding method, determining optimum gains of a plurality of subframes, vector quantizing, updating internal encoder states using said vector quantizations. This is, even though it is a small claim, it is a very, very broad claim. And the way it is going on is, it is saying that, see, now I'm speaking to you, I'm using this particular patent's technology. And this is, it says linear predictive analysis by synthesis coding, but this is speech encoding. Uh, uh, and it is called as adaptive multi-rate coding. So this is just one of the patent for this particular families of AMR coding. So what is this patent is doing something that it takes my voice, converts it into a digital waveform, takes certain inputs from it, and then at the other end recreates the input. That's what AMR is. So depending on the conditions over here, it is taking my voice, converting it, and then recreating the same voice at your end so that you are able to hear it without any distortions. The data rate used is very less. So that's the importance of this particular patent, and that's what it was granted for. So let me just pull up the first one. So under the PCT, when you file the international application, you get something called as international search. So you see these A references, A references, A references. And here you see this X and Y. So what this report is saying that these A documents are generally pertain to the art, but this has got both novelty, and it is not obvious to anybody. I'll try to enlarge this for you. So see this X, document of particular relevance, the claimed invention cannot be considered novel or cannot be considered to involve an inventive step when the document is taken alone. And why? Document of particular relevance, the claimed invention cannot be considered to involve an inventive step when the document is combined with one or more other such document, such combination being obvious to a person skilled in the art. You see this? This is the same as our Patent Act language. So this is why the patent law, even though it is jurisdiction wise, but at the background, the US, European, Japanese, Indian, they are at the same level. We might be somewhere here, but everywhere they are at par. There might be some differences only, but otherwise they are at par with each other. So very general, kind of a thing, that good examination report for this guy. They are saying that yes, it is inventive. It has got an inventive step. It is novel, and let's see. So they're saying this is claiming priority from 16 this application 16/9/1998. This is the Swedish priority application. I'll see if I can pull this up. Okay, so this thing probably didn't even go proper examination. Okay, let me just try to, you know, pull up the US one for it, because our patent office did not go ahead and do a proper examination. So what I'm doing here is I'm taking up the search engine specifically for patents called WIPO Patent Scope. If you just search for patent scopes, you'll come to the same thing. So I'll do the same search, linear. I'll search for linear predictive analysis by synthesis. That was the title. Okay, so I ran into error. I I'm not getting the thing by the title. So let me just look, uh, try to search for another way. So this is a good way if you know the inventor. I realized that I didn't remember. So I went to the Indian application, saw the inventor name, and saw it. So this is what it is. Again, we are seeing all applications by Eric Akuden. And the one we are looking for is Eric Akuden. Found it. Okay, so this is what this is the family member, and let's look at this. So for any particular PCT application that you want, I mean, this file will have the entire details. This is why it doesn't have. Let me just show you another one. Sorry, this is taking another one. Okay. Okay, so this one, I mean, you see this statement that for this particular application, the claims don't have novelty, the claims don't have an inventive step, but the claims do have an industrial applicability check. So they've at least passed one out of the three requirements. Okay, so they're citing, certain documents D1, 2, 3, and if you, let's say go up, so what they are saying is that claims 1 and 6 are not new. So they're saying D1, D2, D3. They're applying three references, each taken alone. Document D1, provides all the features of this particular invention that we are analyzing. It says a method to determine the location of a user indoors. So this is what the claim is. The claim is what is given over here. We are saying a D1, section 24, it this does this. Section 46 does this. Section 52, section 74, 75, 58, 77. The subject matter of claim 1 is therefore not new. So everything is disclosed by one single reference. And so D1 does this, and D2 and D3 are, they're saying just take any one, D1, and hence everything is known in the art. So this is why it is not novel. And they have given out the reasons. And this is the US application. It also has the US data. I think it should have the US data. So you see this certified copy of foreign priority application. So this is a provisional application that gives the priority date. So remember the art that I was saying, the examiner can't cite anything prior to this particular date. So this is a provisional. 27 August 2013 is when this application was filed. This is a provisional, and we have some basic details. It won't have claims. It will just have an abstract, right? So this is why it is very important that the date of the priority document be looked at, because one, in examination, the examiner says cites anything against me that is after this date of 27 August 2013. I can tell him, look, boss, you can't do this. My priority date is 27 August. Cite anything, but prior to that, you can't cite anything that is after this date. And there have been cases where the examiner has cited, something that is after, and the examiner was overturned. This doesn't have claims. Obviously, this is following from the Act. Provisional application is usually not required to have claims, but what patent attorneys usually suggest is that you define the claim. That is what you add the claims to this provisional application directly. You just file it with the claims itself, so that in the case number one, if you have a problem later on, you want to convert it to a complete specification, you can do that. Or sometimes attorneys add it to the patent application because it broadens the scope of the invention. because generally they are designed, written like that, that they encompass a lot more than what is actually disclosed in the provisional. The other thing that is there is, that you must make note of, is the difference between the complete and provisional applications. A provisional application is a placeholder. It is never examined, never, looked at. It is just a placeholder, just gives you a date, a place in time, that this is when the applicant, filed it in the patent office, obviously, and whatever prior art that you look at will be prior to the filing date of the provisional application. And it should be clear, for because you are litigators, you should know that the complete application should be supported by this disclosure in the provisional. It can't be that I write something in the complete application, but it is not supported by this particular provisional. It's because it is this application. This application is telling that I had this idea at this particular point of time, the day I filed my application. That is when my clock starts to run, because after that, nothing can be cited against me in my application. But everything before that, so obviously the basis of prior art becomes this particular filing date. And that's why this date is taken for uh, to determine that whether at this stage you had the disclosure or not. And if a person skilled in the art, obviously it has to be a person skilled in the art, can make sure that this disclosure is there in the provisional. And yes, this fellow is disclosing this particular idea, the way it is to be done. Maybe not complete, but at least some part is there of that particular idea. Only then can you claim priority. This is the same across the globe. It is same in the US, same in India, same in Europe. The complete application, or in the US they call it as a non-provisional, must be supported by the content of the provisional application. So that's why they require priority application. Um, so let's look at this one. So this is the US examiner looked at this particular application. You see how important priority is. Filed on so and so. Priority is this is uh, the first thing that is coming on, because notice of pre-IA, this is statute that this has been filed after so and so. So hence this particular law will apply to it. And this is the next one. It is that important. So 102 is the US rejection, saying that the claimed invention was patented, described in a printed publication or in public use, on sale or otherwise available to the public before the effective filing date of the claimed invention. So don't go by this filing date, it is the priority date. Claims 1, 2, 4, 6, 7, and 9 are rejected under 35 USC 102A as being anticipated by Khorshadi. This is D1. Regarding claim 1, Khorshadi discloses a method to determine the exact same thing. Paragraphs 41 to 43, figure 1, mobile device, so and so, so and so. Everything is disclosed. So one single reference destroys novelty. Similarly, Khorshadi kills claims 2 and 7, claims 4 and 9, claim 6, etc., etc. Just one application, he's killed it. Then 103. So under 103 is saying that this is obvious. So a patent for, and compare it with the Indian section 21JA, a patent for a claimed invention may not be obtained notwithstanding the claim invention is not identically disclosed as set forth in section 102, or it is not anticipated. So this guy is saying even if it is not, this invention is obvious. If the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date, once again this is the priority date, of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains. So 103 for obviousness. For Shadi in view of Fastener et al. So he is combining two inventions, two patents, claims 3 and 8. For Shadi discloses all applications, but does not expressly disclose features of this particular claim. Right? So this examiner is overcautious. So he's saying even if you agree that claims he didn't reject claims 3 and 8 earlier. So now he's saying even if you combine claims 3 and 3, 1 and 3 together, uh, Forstner discloses system, the method for tracking and guiding personal data location. So that is it. So you take combine two, it would have been obvious to one of ordinary skill in the art at the time the invention was made to modify Khorshadi's invention and arrive at the present invention by including the above features. Similarly with claims 5 and 10. So he is taking care of all the particular, replies that I could have done and just rejected it, saying that one, it is anticipated. And even if you try to make certain arguments regarding claims 3 and 5, which are, he doesn't say they are anticipated, but he says that they are, obvious because you can combine Khorshadi with the other one to say that this is not, not to be granted a patent. So this, takes care of three basic aspects. And one other issue that I would just, talk about separately is our act talks about, what is not to be granted a patent. And so you will, once again, you will have equivalents of this in the US, in Europe, in Japan. Basically, every country will have a similar provision. So in the US, they have something called a Section 101. These guys say anything man-made under the sun. So they are very broad. Europe, they also have something under Article 53 or 52, I believe, and they also have a list of things that are there. Of course, not as big as ours, but similar. For example, one common one that is there is Section 3K, a mathematical or business method or a computer program per se, or algorithms. So in the EPC, they have computer program as such. So instead of per se, they have as such. That is not patent protectable. So let's me just come to some examples. Um, so this is one case law. So this is regarding section 3 C. The Patent Act excludes from patentability the mere discovery of a scientific principle or the formulation of an abstract theory. Let's see. Or discovery of any living thing or non-living substance occurring in nature. So let me just ask you whether seeds are they patentable or no? So just raise your hands. Okay, so seeds are, direct application, a mere discovery of any living thing or non-living substance occurring in nature. So a seed is, a living thing. So the case law for this is Nusi Vedu Seeds versus Monsanto Technologies. So this was one of the objections that was taken, that you can't patent a seed. It is protected under, not under the Patents Act, but under the Plant Varieties Protection Act. So let's say you obtain a compound for, uh, there is a specific type of a crab, and you obtain the cerebrospinal fluid of that particular crab, and you use it to treat cardiac disorder. Will it be patentable? Once again, this is any living thing. A crab is a living thing, and of course, the substance obtained from any living thing is not patentable. This is under the guidelines. Many more such examples are given under, in different guidelines under the Patent Act. One interesting one, let's say somebody, has a method of committing theft. Can you just guess which particular section would be used? It is amongst the first three, A, B, or C. Method of committing, theft. Which one will the patent office apply to reject that particular application? Of course, I'll try to keep it short. This would be contrary to public order, or of course, you can't, patent such things. So this is what will be applied against, a particular application. Similarly, discovery of a new galaxy. Um, this is under section 3C, so on and so forth. 3D is something unique to our particular act, 3D, 3E. Europe has got some particular, provisions, but they are, though they limited to certain things. You can look at them in under Article 52 of the EPC. In the US, it is mostly, they are more liberal, of course, than us. They have anything under the sun as being patentable. What else? One other section that is important is for you litigators is rights of patentees, subject to section 47, the exclusive right to prevent third parties who do not have his consent from the act of using, offering for sale, selling, importing, for those importing, etc. So similar is the provision under the EPC. Similar is the provision under the US patent laws. And in this way, once you see any particular application, be sure to look at comparable applications in Europe, in US. Look at the file history. What happened over there. If you are defending both as well as you are asserting, because if you look at this particular section, section 8, the patentee is required to give all kind of details as to what happened, what was cited by the patent office. But let's say you have this application, you saw that application that I had pulled up. So they had to cite all applications that were cited against that particular patent in US, in Europe, Japan, wherever. Wherever the patentee has filed the application, they have to file, details of what happened in the patent office in other countries with the Indian office. That is very important because if you don't do that, it might be taken against you. Obviously, it is the language is may. The controller, it may be refused to grant a patent, but be careful. That's what I can say. And while defending and asserting, um, you might want to have a look at the prosecution history of other jurisdictions. With this, I'll come to an end. Uh, Happy to take any questions that you might have.
So we have a set of questions. The first question would be, as in India, regarding patent of a medicine, if a company has a patent of a formula, let's say A plus B plus C, for a particular medicine, and any other company uses the same formula, that is A plus B plus C, and adds a neutral component, is it out of the scope of a patent? If not, what will be the remedy available with the injured party?
Great. So now, this is an actual case. And usually, we have got two types of patents. Either it is a product or the patent obtained by that particular process. So it's either a product patent or a process patent. And you would look at section 107. Let me just have a open it up. So this says who has the burden of proof, 107 and 104, 04A, a burden of proof in the case of suits concerning infringement. So what will happen is, let's say I am the patentee and I have that A plus B plus C, the process A plus B plus C. So as long as I show, because first provided the patentee or person deriving title from him first proves that the product is identical to the product directly obtained by the patented process. So I say A plus B plus C is covered. Whatever you might have done, ultimately you are reaching the same result. I don't care if if D is a delta, small or large, you are reaching the same end product by A plus B plus C, and hence you are covered. Whereas on the other side, you are saying, that it is not the same process, or it is not the same thing. You have to show differences. It is not A plus B plus C. A plus B plus C, this is required. So what you are saying is the patentee did not disclose, let's say D plus E, that is required to be told, and hence the patent is invalid. So you are making that argument that the patentee did not disclose the entire thing, and which is why this particular patent either doesn't work, it is not useful or industrially applicable, and hence, we don't infringe. Or number two, it is not the same patent. It is obvious.
So the next question would be, there is a hypothetical tablet developed by a company to cure COVID, but a similar popular drug had already been produced by an Indian Ayurvedic company, but for common cold, but later found out that it could also cure COVID. The only additional ingredient in the new tablet is Nilgiri thyroid. The new tablet for COVID is patented, the other is not. My doubt is whether the fact that the old tablet was used to cure a different disease would it in any way hinder the claim against validity of patent of the new company.
Okay, so some clarification. Once again, this is a good question. Known facts. See, our patent act. You looked at section 3. We don't give a patent unless it involves is more efficacious. Section 3D of the act. Uh, so I'm assuming that your question is that the patent was granted. So first of all, the traditional knowledge company, the company that made, they can raise a objection that this is not validly granted, and in view of this, and they should be successful because There have been cases where, there is a drug used for a particular purpose. You just can't go on evergreening the drug. That was the purpose of, section bringing in 3D. You just can't go on using the same, formula, because what happens is in drugs, the formula is very complex. So you have got, let's say, maybe millions of permutations of, let's say there is a chemical bond. So in one position A, something is there, position B, something is there. You can choose a list of items, and in just those two permutations, you can reach millions of possibilities. So which one is doing what, you don't know, but the end result is the same. So let's say if a drugs, you have the example of aspirin. So aspirin, not was used for, headaches. So now then they realized could be used for, in small measures, as a blood thinner. So that was one use. For heart disease, it used to be good. Another use. So how long could they protect aspirin? How long can you protect, let's say, the bark of the cinchona tree for curing malaria, quinone? There is a limit, no? How many uses you can find for it. And similarly, for the case of COVID, there is a limit, no? There are so many things that are used to cure cold. You use the same thing, so that can't be used. The patent, if this company goes for revocation, they should be successful.
So the next question is, what are standard essential patents? Are they different from regular patents?
Okay. So standards, we are talking to each other. You are able to hear me out. I mentioned about the technology called AMR, adaptive multi-rate, and this is the technology used in almost all mobile phones, or I think even now we are using AMR. So what the standard says is that, look, we will transmit at a particular rate. You have got a device, I have got a device. Standard says I will transmit at a particular rate, you will receive at a particular rate, and that rate is fixed. So any particular manufacturer that wants to make a mobile phone will have to have devices that transmit at that particular rate and receive at that particular rate. It is only at that particular rate will some device be able to talk, as in able to transmit, and the other device be able to receive. If I am at any other, let's say, frequency, we will not be able to talk with each other. So what is the process of, freezing, let's say, a frequency or a process? We saw that linear predictive analysis by synthesis, so that is one particular pattern that is there. So that is one way of doing it. We freeze it according to that particular way. That is what is a standard essential pattern. There is no other way. Why? Because that is a standard. Everybody does it. If anybody is using LTE, they have to use linear predictive analysis by synthesis, or to be more precise, AMR. AMR involves not just that linear predictive analysis by synthesis, but multiple patents. There are about 30 odd patents held with the two companies, Nokia and Ericsson, and they are the only ones who developed that particular standard, and they are used in LTE. So anybody who uses an LTE device, it doesn't matter if you have an iPhone, I have a OnePlus, or I have a Xiaomi, or whichever device, we will have to use that particular patent or that particular standard to talk to each other. Otherwise, we can't communicate. We are not on the same platform. We can't talk. So that is what is meant by a standard essential patent. It is the same patent, but of course, it becomes standard essential once companies adopt the standard. So LTE uses this particular technology, AMR. You're locked in into using AMR. You can't use any other standard. So today I decide to open a mobile phone plant. I can't use, let's say, any other particular voice waveform transmission. There are other frequency transmission, parameters as well. I can't use those. I have to use linear predictive to be able to make sure my devices are able to talk to other devices. Is that clear?
So Shravya, go ahead.
Sorry, go ahead. Next question, please.
I'm sorry for the inconvenience. So the next question is of twofold. Uh, wh- why one cannot obtain the patent of formulas concerning field of mathematics, or can we say, or we may say that there exists some lacuna or defect in the Indian patent laws, and the laws are not fully developed to cater to the said problem. For example, solution of long calculus problem or algorithms.
Okay, interesting question. Once again, we grapple with it almost every day. And so you saw section 3K, right? And you also saw both that linear predictive analysis by synthesis patent application as well as the other ones. They are mostly equations. I mean, the way you do a particular thing, those equations, describe the thing. But still, you saw they were patented. The patent office raised the objection that they are, you know, computer program per se. But if you see it closely, or if you, let's say, look at case law, so Indian case law is there is Farid Alani versus Union of India, and if you look at the European case law, or there is VETEC patent application. I'm forgetting the number. It is T5469 of 89. But if you forget, it is VETEC. Uh, what they say is per se, this word per se, or in Europe as such, a plain equation cannot be patented. Number one, it is unpatentable under section 21 AC, 2AC, that industrial applicable. It is not industrially applicable. What will you do with the equation? The other one is, you know, let's say you have this entire, we are talking to each other, this entire Fourier transform, they are taking that particular equation, putting it to some use, and then that equation is resulting into something tangible, right? We are having this discussion only because of something that is there, adding some benefit to the machine. So let's say if even if the machine is, I have a computer and my computer is able to work less. So you saw that, it worked at a particular frequency. I gave the example. What if that the choice of that frequency transmission also is all known, even the frequency is known. What if the choice of frequency leads to less work for or savings in bandwidth for the system, or for my mobile phone, or for my computer system? So that is where the invention lies. And that is why it is patentable. A plain, equation. So let's say a method to find prime numbers, of course, is unpatentable. But once you say a method to find prime numbers to generate a secure password, sure, it works. I mean, the entire, encrypted system is working on that particular basis. That every session is a secure session. We are having this session, nobody else, anybody who knows the link, even though the link is public, can join. You just can't have any random person, butting in into our presentation. That is the purpose of things. That is the purpose of that particular equation. That is how it is being used, put to use. It is you. The word is I'm using the word use, but what I want to say is industrially applicable. And of course, it is not a computer program per se, or it is not an equation, or it is not a mathematical, you know, system. You will see similar interpretation in the US, in the EPC.
So, this being the last question, can a non BSc student establish effective practice in the field of patent laws?
Okay. Sure. In litigation, nothing stops you. I mean, There are, judges that I know who are not of a scientific background, but excellent patent practitioners, not just in India but across the globe. You have not one but many examples. Um, that said, when it comes to patent prosecution, uh, I guess that you have to have the same field as I mentioned, because it is not just a question of establishing, your patent practice. Of course, you can be at the office and take part in the proceedings, but how will you do justice to the Advocates Act? That you need to represent to the client to the best of your abilities, and representation here, getting the broadest possible claim coverage. Let's say when you are going ahead and drafting claims, so there you have this issue. You will be able to draft claims only if you know what you're doing, and you require some technical background. Even though you need not be a PhD in that field, you need to be able to put it across. But what you need to put across, you need to know that. So once seen from the lens of the Advocates Act, I guess that the answer is no for prosecution, but definitely yes for litigation and representing your client at the patent office. That you can do. To add to this, the patent office has an exam, section 125 of the act. Um, you know, it lays out the requirements. There are similar requirements in the US. The US also has an exam. Similarly, in Europe, obviously the exam is much more difficult than um, in the US. In the US, they have a full objective type paper. In Europe, they have you're required to draft claims like in India. In Japan, it's even more difficult. So most of the jurisdictions, they require this particular science background. The thought was that you'll be able to do justice to the client. Obviously, it is not just from a practice perspective, from the lawyer perspective, it's from the perspective of the client as well.
We are grateful for your time and guidance, sir. Now we have Jayant Upadhyay for a vote of thanks.
Good afternoon, everyone. With this, we come to the end of our workshop on patent, trademark, and copyright practice. At this juncture, I, Jayant Upadhyay, on behalf of KLU Society's Law College, Bengaluru, would like to extend my profuse vote of thanks to the resource persons for their highly insightful, informative, and lucid interaction. I am grateful to the speakers for their valuable time, for taking valuable time out of their busy schedule to grace the event and making it a resounding success. I would also like to extend my special thanks to our principal, Sir Dr. J.M. Mallikarjunaya, IQAC Coordinator Dr. Manoj Kumar V. Hirmat Sir, and Faculty Coordinator Ms. Shimona White Ma'am for providing us immense encouragement, support, and guidance to organize this workshop. I must also not forget to thank my fellow coordinator, Ms. Shushavya Ji, for working hard for the last few days to make this workshop a possible one. And at last, my thanks to all the attendees for their active participation. And thank you all once again for making this workshop an exemplary one. Thank you, everyone. Have a great day.
Thank you so much, sir. Thank you, Neil, sir. Thank you, Rajiv, sir. I'll end the meeting now. Thank you so much.